Happy Friday.
Yes, happy Friday to you too. Audio and video sound good? You're good to go. Morning, Chair Mitchell.
Hey, John, checking my mic.
Audio and video sound good? You're good to go.
All right, thank you.
Sure.
Does my audio sound okay?
Yes, sir, it does. Audio and video look good. You're good to go.
Thank you.
Last call for audio video check. Please turn on your video and raise your hand and I'll call on.
Hey, John, it's Steve Feder.
Good morning, sir. How are you doing today?
I'm okay. How do you hear me? I take it.
Yes, audio and video look good. You're good to go, sir.
Okay, great. Thanks a lot. Have a good day.
You too.
John, has Commissioner Gray checked in with you?
Yes, he has.
So he is here.
He is.
I just don't, there he is. I finally see him on my screen. That's great.
Just taking a little break.
You're entitled to it, I'm sure.
No, you're the one who's entitled. Got to it. Wow.
All right. It looks like we have everyone assembled who needs to be assembled. So we will come back to order here. And this is, we're in the middle of the panel, but it's also at the beginning of questioning by the Attorney General's office. So this might be a convenient point if there are any overnight procedural matters we need to address. This might be a convenient point to get them out of the way.
Commissioner Klopfelter, when we did yesterday, there was discussion whether or not Duke was going to stipulate to those two exhibits or that we would recall later in the day Michael Manis to sponsor them. And if Duke said they would consider it overnight, if they could give us their answer, then Mr. Manis would know how to proceed.
Yeah, Commissioner Klopfelter, I apologize for not jumping in sooner.
That's quite all right.
I do have a response to that, and I do appreciate you allowing us the overnight period to consider the objection. As you're aware, as yesterday, we objected to primarily public staff potential exhibit 100, which I believe now is, and you can confirm for me, is marked as Doss Spanos Riley cross exhibit, I believe 7.
That's correct.
Okay. We have conferred on that in the interest of judicial economy and to avoid any interruption in our rebuttal case. We do agree to withdraw the objection to the exhibit's admission into the record. However, I would like the record to reflect that the exhibit depicts the public staff's position that 50% of even prudently incurred costs should be disallowed under the auspices of culpability, which is a position adopted by no regulatory commission anywhere, and which is not contrary to the basic regulatory compact that underlies the regulations in this country. So with that, Commissioner Klopfelter, we would withdraw the objection.
Thank you, Mr. Marzo. We understand the document reflects the public staff's position, and that's apparent from the face of the document. These are, as I looked at them further overnight, especially exhibits 7 and 8, they're essentially summaries of a lot of data compiled to show what the data would be under the public staff's legal position in the case. So I think they would probably be admissible as summaries of data compilations under Rule 1006. But I appreciate your stipulating to them. That does save us some time. Can I ask if you're also prepared to stipulate us to exhibits 6 and 8?
Commissioner Klopfelter, we would withdraw the objection generally to all those exhibits. So we are allowing all those exhibits to.
Well, then when we get to the end of the panel's testimony, we'll take motion for actual admission at that time. But at least you've clarified the process we'll use for the day, and Mr. Manis may have Friday off then. So thank you for that.
Thank you, sir.
All right.
He would appreciate that. Thank you.
Is there anything else? Mr. Robinson, anything from you?
No, sir.
Okay, thank you. Ms. Force, the panel is with you.
Good morning. Thank you, Commissioner. Good morning, gentlemen. I see, I don't see Mr. Riley, but I have questions for Mr. Doss and one for Mr. Spanos. So
let's hold just a second. I'm sorry, that's neglect on my part. Do we have Mr. Riley with us?
He's there now.
Yes, sir.
There he is. I see him. Okay.
As I said yesterday, I have a couple of questions that follow up on Mr. Grantmeyer's questions yesterday, and they all relate to accounting for coal ash, closure and disposal of CCR. And there are two documents you won't be surprised that I'll be referring to. One of those is the 2003 order on ARO accounting that you talked about yesterday. And that document is already admitted in the record as Smith AGO Cross Exhibit 6, and it was in our potential exhibits as number 34. And the other document is the 2016 petition for an accounting order that was submitted jointly by Duke Energy Progress and Duke Energy Carolinas. And for reference, that is AGO McManus Sparrows Cross Exhibit 1 that was entered in this record by stipulation and was provided as AGO Exhibit 40 in this proceeding. Do you have those in front of available?
Yes, I do have those available. Yes.
Okay. So
I'm sorry, Ms. Force, those were, I got the marking on ATO McManus Spiros 1. What was the other number?
I'm sorry, and those are both admitted already.
They are, but I just want to, from my notes, what was the other one that you?
Sure. The other is Smith AGO Cross Exhibit 6, which is the 2003 order for the name is CP&L, Duke Energy Progress. Several other names apply during that time frame.
Thank you. I know those have been admitted previously. I just needed to note them for my tracking sheet. Thank you.
Sure, sure, and for reference. Okay, so as we discussed in the DEC case, Duke filed a petition for accounting order in the rate case, the last rate cases, before the last rate cases, in a separate docket on December 31st, 2016, right? I'm referring to that petition.
That's correct. Yes. You want me to have that available? Let's see.
We're going to get to it later, but it makes specific reference, as you did yesterday, to the 2003 ARO order as support for the deferral. Am I right about that?
That's correct.
Okay, so let's turn to the 2003 order, and this is what ties back to what you talked about with Mr. Grantmeyer. There are a number of points in that order I just want to highlight relate to your discussion. One of them is on the first page at the bottom, under background, the second paragraph, indicates that PEC, which is Progress Energy Corporation at that time, it's DEP now, indicated that the only significant retirement cost expected to be an ARO is the radiated portions of nuclear plants at that time. Is that right?
That is what's indicated in this paragraph. I will note that later on it mentions those as well as other AROs.
Okay, that's fine. And then turn to page 11 of that order, please. There's a paragraph there that talks about depreciation expense, and it indicates that that as part of the function of depreciation rates included a component of the company's North Carolina retail cost of service established in the company's rate cases, included cost of removal. Is that right? In that paragraph, let's see, it would be the fourth paragraph on page 11.
Yeah, I think that what it is trying to indicate there is that prior to 2003, when FAS 143, which was the GAP ARO guidance, before that came out, we would have been collecting perhaps some amounts through the cost of removal accounting method, where we collected that through our depreciation expense for costs that would be incurred upon the retirement of assets. And so I believe that what was trying to be addressed right here is that to the extent that we had those types of costs, I think this was the big concern back in 2003, to the extent that we had those already embedded in customer rates through collections and depreciation expense, that once those are pulled out as an asset retirement obligation, you need to distinguish those from amounts that had been previously collected through your cost removal and your depreciation. So it was trying to make that distinction.
Okay, and so what it said at the end there, or in the middle of that paragraph, is consistent with the economic consequences of that regulatory treatment. The cost of removal is accrued and recognized as an operating revenue deduction over the useful life of the related assets, rather than waiting to record the expense until the assets are actually removed and the related costs actually paid, right? That was a direct quote. Do you see that?
Yes, that is a direct quote. That's right.
Okay, and then on page 12,
excuse me. This is the court reporter. Mr. Doss, if you could mute while she's speaking, we're getting some feedback when you're both on at the same time.
Okay, thank you for telling me. I'll do that too.
Thank you.
On page 12, that top paragraph is just a partial paragraph. There's a statement that any proposed changes in cost of removal for long-lived assets and/or in accounting for such costs must be submitted to the commission for its approval in the context of a general rate case or other appropriate proceeding prior to implementation, correct?
So sorry. I believe that's getting to what I was pointing to before, which is that we had a mechanism where we were collecting these costs through depreciation expense. And to the extent that we needed to consider that as we moved into ARO accounting, we wanted to make sure that those were considered appropriately, as we talked about in the last case, so that we make sure that we're not double recovering, right?
There. Okay, my button wasn't working right. So just a couple more. In the ordering paragraphs, then it indicates the intent and outcome of the deferral process under A shall be to continue the commission's currently existing accounting and rate making practices for nuclear decommissioning costs and other ARO costs, as you referred to earlier, correct?
Yes,
and
that's
then in
2A says.
Okay, and then in paragraph C, the commission ordered that the implementation of SFAS 143, the ARO accounting, for financial reporting purposes and deferrals allowed in this docket shall have no impact on the ultimate amount of costs recovered from the North Carolina retail ratepayers for nuclear decommissioning or other ARO costs, subject to future orders of the commission, correct? Which is, you mentioned that in your testimony, actually, too.
Yes, effectively what they asked us to do is that they wanted to see our books and records, have some deferrals that would essentially remove those impacts.
Okay, and then the last paragraph I'll refer you to is paragraph F, where it says, as part of this pending further order, no portion of the total ARO asset or liability shall be included in rate base for North Carolina retail accounting or rate making purposes, right?
Yes, that's what it says. That was very common across the industry. One of my fellow panelists, Sean Riley, mentioned that in his testimony. And if there's additional questions on that or additional thoughts that Sean might have to add to the context here, that was pretty typical across the industry and the utility industry.
Okay, I don't have any questions. Maybe you can take that up on redirect if you'd like. Moving back to the petition in 2016, in that petition, the request that was filed as to DEP was to defer $2.4 billion, the total amount of the obligation as anticipated at that time or estimated. It is for the ARO. Is that right? If you can refer to page 9, paragraph 11.
I thought that number sounded familiar. Yes, 2.4 billion was the number for DEP at that time.
Thank you. And then the number, so that's the total ARO amount. Then there was also a request to defer amounts as spent. And at that time, from the period of January 1st, 2015 through November 30th, 2016, the amount had accumulated of $291.9 million, correct?
Yes, so some context here on what we're attempting to do here. So from the 2003 order, as we just went through, that gave the company the authority to defer the income statement impacts of the FAS 143 as it applied to our coal ash remediation obligations. Essentially, that order told us to remove the income statement impacts through deferral entries so that it didn't change our income statement because of the impacts of applying ARO accounting to our coal ash obligations. And what this request here now, so that gave us the authority to defer those costs. Think of those as non-cash costs. We're accruing for those obligations, but we haven't spent any money yet. In 2016, we came in because in 2015, we had started to spend some money associated with these requirements under CAMA and the CCR rules. And as a result of that, we needed to come in and start requesting kind of continuation of the process that was established back in 2003 as far as how the commission wanted us to handle this. In that 2003 order, the commission said defer those non-cash impacts until such time we can consider this in a rate proceeding or some sort of regulatory proceeding. And now that we've started to incur the cost, this request was to, as we settle those obligations that we've already established, these capital obligations that we established in association with ARO accounting, and we're starting to settle those costs through paying cash and relieving that obligation. What we want to do now is we want to start reclassifying some of these costs that had been in the deferral account. That was a non-cash account, what we called our theory regulatory asset that was established from the 2003 order. And now we want to just reclass those amounts as they are spent into a new regulatory asset that reflects amounts, cash outlays to settle these obligations.
And so I think it would be your position that that's not a change in accounting from what had been approved previously then?
The change in accounting, let me say what, as far as a change in accounting, we're starting now to settle that obligation that had been established. And we're asking for authority to create a new regulatory asset that will just allow for the transfers from the theory regulatory asset, sort of a non-cash amount, into this cash spent account. As far as a change in accounting, we think that it was prudent for us to, as the commission asked in 2003, that we set these amounts aside from the initial application of ARO accounting until such time we can come to the commission and allow the commission to start addressing the actual costs incurred.
Okay, and in the petition, there is a reference to account 182.3. That's a FERC account, right? That would be used for recording the deferral as a regulatory asset. Am I right about that?
You are right about that. That is typically the way that deferral accounting works, and that we request permission to use a 182.3 account to defer costs to. So this is, in effect, asking for permission to start transferring costs from that previous theory 182.3 account to a new 182.3 account to reflect amounts spent.
Okay, and then in doing so, then that would signal that the anticipation is that probably those amounts deferred would be recoverable in a different period. Am I right about that?
Well, and this request, just to be clear, we were very clear, I think, in the request that we were just asking for deferral authority. And you mentioned recovery. And it said that we would be addressing the recovery phase of this in a future proceeding. I think that we had said that, if I recall, that we would be filing rate cases within the next year or so at the time that we made this filing.
Okay, and that FERC account indicates that it's a regulatory created asset not includable elsewhere are included that result from rate making actions of regulatory agencies, right?
That's what a 182.3 account is for, yes.
Okay, and if that deferral account were not used, then would it be an amount that for instance, in the Sutton, the amount related to the Sutton plant would have been written off?
I'm not sure what you're referring to on the Sutton plant, but I would say this is that in 2015, when we started to incur these costs, we actually filed an informational filing. You may recognize it as the Savoy letter. It was actually attached to our 2016 deferral request, laid out very specifically what accounting we were using. And as I spoke yesterday and responding to questions to Mr. Grantmeyer, I alluded to this, is that for accounting purposes, what we do is in order to record amounts into a regulatory asset, we have to make an evaluation or an assessment as to whether those amounts are probable of recovery. And sometimes there are times when we make that assessment before we actually have official approval to open a 182.3 account. In those cases, we follow commission guidance. We don't create it. We don't start using a 182.3 account until we have actually received authority to do so. But we believe the amounts to be probable of recovery. So per GAAP rules and per FERC rules, we're required to defer them. And so what we do in that case is we use a 186 account. Actually, a 186 account is used for GAAP purposes on our GAAP financial statements. It actually maps to the same line item as a regulatory asset. But for our regulatory reporting purposes, there is a difference between a 186 and a 182.3. A 186 is something that we use when we're required to, per the FERC rules, per the GAAP rules, after making that assessment that we believe it's probable of recovery, but before getting the approval for the 182.3, we use that 186 as a holding account.
I see, that's helpful. And in any event, the way it's mapped then does signal to the investment community that it's the company's belief that it's probable that this amount will be collected in future periods.
That's correct. And that goes through a thorough evaluation and assessment with the accounting team, the rates team, and the legal team to make that judgment.
Okay, and there were some arguments that were made. They're already stated in that document. I'm not going to run through those with you this time, Mr. Doss, to save some time. But I do want to introduce an exhibit that will be familiar. If you please turn to AGO Potential Exhibit 36. And that is an EPRI document titled Decommissioning Handbook for Coal-Fired Power Plants. And Commissioner Clodfelter, I'd ask to mark this as AGO. Well, maybe I've got the order wrong. Under your convention, I guess it would be Doss, Spanos, Riley, AGO, Rebuttal, Cross Exhibit 1. Is that correct?
Well, that is correct. This is the first new exhibit, so it would be number 1, correct?
Okay, thank you. Did you find that?
I did find that exhibit, yes.
And I'm sorry, I'm getting confused about whether I'm muted or not. I'm back on. You've seen this before, I guess, because we talked about it a couple of weeks ago. If you would, I just want to signal on page 2, it indicates that this is a document from November 2004, correct?
Yes, that is what it indicates.
And it's a report on decommissioning of coal-fired power plants. And if you would turn, please, to page 2-5, maybe you can agree with me. I'm reading this sentence correctly, closure of surface impoundments and landfills probably will be the most expensive task undertaken during the decommissioning process. That's one of the, appears to be one of the conclusions of this report. Would you agree?
Well, and I think I may have said this before, I'm not familiar with this report. I agree that that's what that sentence states. I don't know the context. I really think, Ms. Force, that for this would be better questions to ask of our coal ash specific witnesses like Mr. Narsick, Mr. Wells, and Williams. This is not a document that that I'm familiar with.
Well, Mr. Doss, you are familiar with EPRI, are you not? The Electric Power Research Institute.
I have heard of EPRI. Yes. It's not really for accountants. It's not an organization that we typically refer to a lot for our accounting guidance and for accounting regulations.
Well, the document will speak for itself, but I think I'm going to ask for it here. This has to do with the cost element of it. That particular statement does, and that's my purpose in asking you the question. And I don't have any more questions along the line.
Mr. Chairman, I was just going to say, to the extent this document, Ms. Force has questions. I think clearly the witnesses indicated that the witnesses that are following immediately after Mr. Doss will be able to answer those questions, and that may be a better forum to try to enter this particular document into the record.
I think I understood Ms. Force to say that you didn't have any additional questions for this panel on the document. Is that correct? Did I hear you correctly?
That's right.
So, Mr. Marzo, I think your concern here is moot. She's not going to ask any more questions about it of this panel.
Commissioner Clawfilter, just to confirm, and I think this was part of your determination yesterday, that to the extent these questions are not asked to those later witnesses, I assume this is one of those issues that can be used in our direct.
Sorry, I was on mute. That's correct. You are not, of course, on your direct examination, you are not limited to the pre-filed testimony. And if you have supplemental direct that you need to use for the purpose of exploring a topic that has come up in the testimony of another witness, that's one of the purposes of supplemental direct.
Thank you, Commissioner Clawfelder. I just wanted to confirm that.
Sure. Ms. Force, you're on mute again. Ms. Force, you're on mute.
I'm sorry. Mr. Spanos, I do have a question for you about your testimony on page 35. On line 14, you say the earliest depreciation study dated as of December 31st, 2002, and that would be the company did progresses, was in, I believe it says there E2 sub 828, reflects a calculated net salvage percentage for equipment and facilities subject to the study, which would include coal ash basins as part of the plant facilities, although not in any specific dollar amount. Do you see where I'm referring there?
Sorry. Yes, I do see. I just want one clarification. I believe the discussion is related to a decommissioning study within a depreciation study. I wasn't sure if that was what you were referring to in this section, but I wanted to make sure that I was on the right page, that we were, there's 3 decommissioning studies that were conducted and as part of 3 depreciation studies.
Okay, I'm referring to the one that was dated, according to your testimony, December 31st, 2002. And that study was filed with the Utilities Commission, let me see, on March 10th, 2004 in that docket. And when I look at that study, I think what you may be referring to there, I'm reading from that on page 311, that the cost of removal includes such costs as demolishing, dismantling, tearing down, disconnecting, or otherwise removing plant, as well as normal environmental cleanup costs associated with property. Would that be consistent with your statement and your testimony?
Well, first, just to make sure that that we're clear with the process, the study was done as of December 31, 2002. It was a depreciation study. I was not the one that performed that study, but again, based on what I've described, the precision in decommissioning studies and the information that's included in decommissioning studies and how it is applied to a depreciation study are much more precise today because of what we know with regards to AROs. So at this particular time, the information is consistent with what was described. There were many components of the decommissioning study that many of them that you read off were accurate. It does not specifically talk about all of the different environmental components that were built into that study. They're not precisely identified, such as the coal ash basins, which is what I talk about on lines 12 and 13.
Okay, I understand. I think you mentioned that in your testimony as well. I don't have any other questions for the panel. Thank you very much.
Thank you, Ms. Force. We've come to the point where I don't have any other parties who indicated an interest in cross-examination, but for the record, I'll ask, are there any other parties who have questions on cross-examination for this panel? If there are not, Mr. Jeffries, Mr. Marzo, we're back to you on redirect.
Thank you, Commissioner Clodfelter. Just a few questions. First off, Mr. Riley, I believe that the AG, Ms. Force, had referred you to what is Smith AGL Cross Exhibit 6, which is the 2003, or referred Mr. Doss, I'm sorry, to the 2003 order on deferrals. And specifically, she had referred Mr. Doss to Section F of that order, which refers to the rate-based treatment of ARO assets and liabilities. And Mr. Doss at that point in time thought you may have more to add on that based on your testimony. Could you please elaborate on that particular provision and how AROs are considered in terms of their treatment in rate base?
Certainly. So, and I do talk about this in my testimony as well. Witness Doss talked about, he talked a lot about cash and non-cash. It is not uncommon, and I would say it is consistent with industry practice not to include asset retirement costs and their associated asset retirement obligations in rate base because they are effectively accounting entries. We call it a balance sheet gross up, where the assets have been increased and the liabilities have been increased on a balance sheet, but it's a result of accounting entries that are required under what was referenced FAS 143. It is not an outlay of cash. There has not been use of shareholder funds. There has not been use of customer contributions either, and therefore there's no adjustment to rate base as a result of ARO accounting.
Marzo, you're muted.
I'm sorry, thank you. Getting used to that myself. Mr. Doss, Mr. Grantmeyer asked you some questions about the recent Dominion rate case order yesterday. Do you recall that?
I do recall that, yes.
And he asked you specifically whether you were aware that in that case, the commission ruled that base enclosure expenses were deferred operating expenses. Do you recall that?
Yes, I do recall that.
And he asked you further whether the commission in that order agreed with Mr. Manis' position that the expenses were deferred operating expenses. Do you recall that?
I do recall that, yes.
Now, do you know the factual basis of the commission's findings of the Dominion case, rate case?
I don't know the factual basis or all the context around that order. I did peruse the order.
Okay, and I was just going to ask you, do you have Exhibit D, what is Duke Energy Progress's Exhibit 3 with you? And for the record, Commissioner Clodfelter, I'll just indicate that this is the DNC rate case order from February 2020. I'll just ask the commission to take notice of this order, obviously.
That's correct. The commission will take judicial notice of its own prior orders without marking them separately as an exhibit. If you want to mark them for purposes of managing the record, that's fine. But the commission will take judicial notice of its prior order.
Thank you, sir. If you would for me, Mr. Doss, would you return to page 134 of that order?
Yes, I'm at 134.
Okay, and do you see the first full paragraph in the order?
And that would be the paragraph starting with additionally?
Yes. Would you for me, would you read the first two sentences of that paragraph?
Certainly. Additionally, at the hearing, witness McLeod confirmed that the vast majority of the CCR expenditures were for services and labor and would have been charged to operation and maintenance expenses in the absence of GAAP ARO accounting requirements. And there's a reference there.
And that's a reference to an exhibit that was used on cross. But if you could read the next sentence.
Okay. He also confirmed that roughly 98% of the CCR costs incurred during the deferral period would have been booked as operation and maintenance expenses, but for GAAP accounting requirements.
Okay, thank you, Mr. Doss. Does the record in this case support the proposition that the basin closure costs the company is seeking to recover in this case are operating and maintenance expenditures?
No, that's not what we believe in our case is to be true. The costs associated with basin closure in our case are part of the ARO. And as I've indicated in my testimony, and as Sean Riley has indicated in his testimony as well, is that in ARO accounting, those costs are capitalized as an integral part of the plant that gave rise to the obligation. So it's a capital cost.
Okay, and likewise, in our case, is the proposition that 98% of the closure costs will be booked to operation and maintenance correct in this case, the Duke Energy Progress case?
No, our costs, and I've got this in my supplemental testimony as well, where I indicated I did a review of the costs from Jessica Bednarsik's supplemental testimony, and concluded that those costs were part of the ARO, and as such, as ARO costs, they are capitalized as part of the property, plant, and equipment that gave rise to that capital obligation for retirement.
And I think,
Mr. Marzo, could I add
sure
to that?
Sure, Mr. Riley.
Because I think that's a very important point. If you step back, and we've talked about this in our testimony, but under ARO accounting, the company has to evaluate what its legal retirement obligation is. And that would include all activities associated with relieving itself of that retirement obligation. All of those activities will be forecast out in terms of when cash expenditures will actually occur, and then it's present valued back using a credit adjusted risk-free rate of return to come up with what the asset retirement obligation is at a point in time. The offset to that adjustment is an asset retirement cost that witness Doss is talking about. That's a capital asset. And to be clear, the FASB was extremely focused on this point that, and I believe witness Doss actually referred to this yesterday, that those costs are considered integral to the operation of the asset, in this case, the coal plants, and therefore should be capitalized. So there's no real nature of operating expenses or capital expenses as it relates to asset retirement obligations and their associated asset retirement cost.
Thank you, Mr. Riley. Mr. Doss, in regards to Duke Energy Progress, has the commission spoken previously on this issue in terms of the accounting and the related treatment of ARO's capitalized costs?
Yes, they have actually in the Duke Energy Progress case, as well as the Duke Energy Carolinas case previously from a couple of years ago. The commission agreed that these were not in the nature of deferred expenses, but these were in the nature of ARO costs, which were more closely aligned as capital costs.
Now, what effect does the purpose for which costs are incurred have upon the proper classification of costs?
Well, it's everything. You know, in reading through this, what the witness for Dominion said that these were services and labor costs. There seems to be an implication there that because it's services and labor, that somehow defines it as operation and maintenance, which couldn't be further from the truth. As I've said in my supplemental testimony, we need to know what the purpose of that services and labor is for. And I can give examples, for instance, at our company, if I'm at a warehouse and I see a truck leaving the warehouse with some materials and supplies and it's going to a job site, I don't know whether that's expense or that's capital in nature. I need to know what the purpose for that is. If, for instance, it's going to a job site where they're doing some repair of a distribution line after a storm, that's an expense activity, and therefore the cost of that truck rolling out, carrying the materials, the person driving the truck, all those costs will be considered expense. However, I could see another truck leaving from that same facility, also with a driver in the truck, some materials in the truck that's going to, for instance, a site where we're building a generation plant. Same activity, but the purpose is for a capital construction project, and that cost will be charged to capital. So we need to understand the purpose of that activity. You can't look at the activity itself. I have to do this every day with my own asset accounting team. I have something in the neighborhood of 60 accountants working for me. About 1/3 of my costs are charged to capital for my group. I can't walk through my group and just see labor and services going on, which is my entire budget, really, labor and services. I can't just see somebody doing debits and credits, working on a project and so forth. I can't know from it being labor and services whether that's capital or O&M. I have to ask that person what they're working on. And in fact, we have strict controls around this at our company, and strict controls in my group where twice a year I review how my accountants are charging their time. I need to know what they're working on. And it's so critical in determining whether it's a capital or an O&M type cost. But it appears from looking at, if you can envision two accountants working in a cubicle side by side, it looks like they're doing the same thing. I need to know the purpose of their activities.
Thank you, Mr. Doss. And Mr. Rowley, is the classification of CCR expenditures, as Mr. Doss and I have been discussing, consistent with what you have seen in your national practice?
In short, absolutely. That is absolutely consistent with what we see in our practice.
And Mr. Rowley, is the commission's treatment of ARO cost in the prior DEC and DEP orders consistent with what you see in your national practice working with regulated utilities across the country?
It is exactly as how we've talked about it before. I would also add to Witness Doss's comments just a moment ago in terms of his examples. There's lots of other examples that would where it's very difficult to identify if a cost is expense or capital. I think of overheads, benefit costs, for example. Those costs typically follow the labor associated with an expense activity or a capital activity. So you can't just look at benefit costs and determine that they're expense or capital. You have to know what they're associated with.
Thank you, Mr. Riley. Thank you, Mr. Dawes. Thank you, Mr. Spanos. Commissioner Clodfelter, that's all my redirect.
Thank you. Let's see if there are questions from commissioners. Commissioner Brown Bland.
No, I have no questions.
Commissioner Gray?
No questions.
Chair Mitchell?
No questions.
Commissioner Duffley?
Yes, I do have a few questions. I'd like to discuss, and it can go to everyone, but I'm going to refer to Mr. Stanis's testimony. If you could turn to page 36 of your testimony. So what I'd like to discuss with the panel today is the status of the fuel mix in the industry at the beginning of the 21st century. Mr. Spanis, are you at page 36?
I am, yes. So of my rebuttal testimony?
Yes.
Okay.
Okay. Mr. Spanis, I'm not seeing you on the screen. Okay, found you. So on lines 6 through the following page, lines 5, do you agree that a summary of this part of your testimony is basically stating that prior to approximately the mid-2010s, and maybe even later, but in the earlier part of 2000 to 2010, that the prevailing presumption by electric companies at the time was that these coal-fired facilities would continue to provide power long into the future. And that it was not until probably 2009 timeframe, 2009, 2010, 2011, that electric utilities with coal-fired power plants were evaluating potential retirement of those plants because of the tighter environmental regulations coupled with the falling price of natural gas. Is that generally a summary of your testimony?
Yes, that is very accurate. I'll add and hope for clarity that specifically for coal-fired plants, the overall lifespans for these facilities was expected to be 55 to 65 years, which would have taken us well beyond our current time of the 2015 to 2020 period. However, over the last 5 to 7 years, we've seen that coal-fired plants are retiring at ages 46 to 50. That's across the country. So all of that is being driven by environmental issues, the prices for natural gas, all of which I've discussed in my testimony. So the expectation that coal-fired facilities are going to be retired in the very near future is exactly what I'm talking about, and it is driven by multiple issues, specifically environmental regulations and natural gas prices and the efficiencies of other facilities beyond coal.
Okay, thank you. And I would like to request a late filed exhibit. If I could have the monthly history of the Henry Hub natural gas prices in a graph form from August of 2000 through September of 2020. And you should be able to find something on EIA and just have it fit on one page. Have a one-page type graph, please. So you're familiar, are you familiar with the fact that the North Carolina Utilities Commission submits a long-term generation type planning document to the governor each year?
I am familiar that that's filed. I don't necessarily research that, but.
Well, subject to check, would you agree that in 2007, DEP, the electricity production for DEP was, they were producing 49% from coal in 2007, and then only 5% from oil and natural gas?
Subject to check, but that would seem to be a reasonable expectation around that time period.
And then by 2012, coal was responsible for DEP for about 34% of the production, and oil and natural gas had bumped up and was responsible for about 18%.
I'm sorry, which time period was those numbers?
That would be 2012. Subject to check.
Yeah, subject to check. That trend would be consistent with what I would have expected for DEP and for others in the industry for that matter.
And then in 2018, for DEP, coal was responsible for 12%, and natural gas and oil was responsible for, or made up 34%.
Again, subject to check. That trend is exactly what I would expect, and I'm seeing all within the industry. I just don't have the exact numbers for DEP, but that's what I believe to be the case with the assets that are in service today.
Okay, thank you. I have nothing further.
Thank you, Commissioner Hughes.
No questions.
Okay, Commissioner McKissick.
No questions.
Okay, thank you. Gentlemen, I have just a couple. Mr. Doss, I have just a couple for you. I may refer in my questions. We alerted your counsel overnight so you could have it available to you. In my questions, I may refer to an exhibit from the prior Duke Energy Carolinas case, which was marked as Attorney General Doss Cross-Examination Exhibit 1. I'm not going to question you about the document, but I may refer to it. So I wanted to be sure you had access to it in case you wanted to refer to it. Do you have access to that?
Let me make sure we've got that. What's it look? Could you?
It's the title of it is it's the Plant Retirement Comprehensive Program Plan, dated October 2012. I'm not going to question you about the contents of the document. I just wanted to be sure. I'm going to refer to it in my question, and you may therefore want to refer to it in your answer. I didn't know. Just wanted to be sure.
Okay, I'm sorry, Commissioner Klopper. We'll try to get a copy of that, but I'm comfortable trying to answer your questions.
Okay, let's try.
Commissioner Filter, I'm sorry to interrupt. I just didn't know if this would help in terms of your questioning. We are aware of that document and you had questions on it. I think Ms. Bedarsic was given the document and not Mr. Doss. So I did want you to know we heard your request and we did provide a document to a witness.
I apologize. I thought I had referred to both Mr. Doss and Mr. Bedarsic. I don't think we're going to get into trouble in the document. Let me ask my question, and if Mr. Doss says he needs to defer it, we can. Okay. In the rate case that the company filed either in 2011 or 2012, I can't remember which year it was, the company made a request for a specific revenue inclusion in the revenue requirement, a specific item, itemized amount for the costs of closure of coal ash basins, correct?
Yes, I'm aware of that.
And if my recollection is, without having gone back, I haven't gone back and looked at the record of that case. My recollection is that it was an amount of approximately $10 million that the company wanted to put into rates for that purpose.
10 million annually sounds about right.
Okay. And my question to you really is how was that amount? Do you know how that amount was arrived at? How was the estimate of the amount arrived at? Mr. Spanos may have some information to share on this too. Really looking just for where did the number come from?
It was in a, what I know is, and I wasn't involved at the time, but there was a dismantlement study done, I believe, in which those numbers came from that study. I can't tell you the science behind the assumptions behind those numbers. I'm sorry.
I understand. Mr. Spanos, do you know the answer to the question?
Excuse me. There was a Burns and McDonald study that decommissioning study that incorporated those numbers. I don't know all of the support from Burns and McDonald to how they got those numbers, but that was part of the assessment. I was not directly involved, so I don't know all the research behind Burns and McDonald's work at that time. I was much more familiar with the work they did in 2016 because that was for DEP is when I became much more active.
Well, do either of you know whether, I'm really looking for direction here, and I'm not going to make you do the work for me. Do either of you know whether that Burns and McDowell decommissioning study from the 2011-2012 rate case, was it filed in the record of that case? If I went back to the record of that case now, could I find it there? Do either of you know?
It was part of the filing. I will tell you that there's two different pieces in that decommissioning study, one for near-term facilities and one for those that would be further in time, and they are taken care of differently between the decommissioning components. So I think that's an important thing for you to look at as you see it, but it was part of that filing.
That's great. I won't press you further on that. I can go off and do the reading later on my own. And the last question on this topic, though, does connect back to the plant retirement program document. Mr. Dawes, I don't know if you got it. There are in that document cost estimates that look to be internally prepared by the company for what it expected at that point in time. This was 2011, 2012, to spend on closing the coal ash ponds. And I'm really just trying to connect. Do you know who might have developed those internal documents? I'm asking a fairly awkward question. I'm really trying to identify, were those independently developed or were those based upon the Burns and McDowell decommissioning studies? Do you know?
I'm afraid I don't. I remember in the last case, the DEC case, I remember seeing some estimates. I think those were specific to Duke Energy Carolinas. I'm sorry, for Duke Energy Progress, I can't think of or having seen any estimates that may have been done internally for Duke Energy Progress.
Okay, the document does include estimates for both companies. And I just was, again, really the purpose of my question is to find out what the basis for those estimates was, whether it was based upon work by Burns and McDowell or whether it was based upon some other work. And that's really what I'm trying to drive at.
I really wish I could help you. I'm sorry, I just don't know.
Okay, I'll leave you alone on that, and you and Mr. Spanos, I can check the record of the prior case, so I won't press further on that. Mr. Marzo, I would ask maybe just as a late file exhibit answer, if we can just get us answer to that question is, were the estimates in that document, Attorney General Doss Cross Exhibit 1, based upon the Burns and McDowell decommissioning studies that were filed in the earlier rate case, or were they prepared independently from some other source?
Yes.
So I'm trying to find out.
We can get that for you, Commissioner Clawfield.
Thank you. Another topic, Mr. Doss. Were you listening or observing when Ms. Bednarsik testified on direct examination?
I was not, but I did speak to Ms. Bednarsik yesterday, and she kind of gave me an overview of her testimony yesterday and gave me a heads up that I might get a question.
Well, you're going to get a question. I'm not sure which one she gave you heads up about, but I had she deferred this one to you. I had asked her a question that see if I can summarize it without going back through the whole sequence. And let's take the Roxborough plant as an example. I think it was Roxborough, Sutton, and perhaps one other, but let's use Roxborough as the example. At the Roxborough plant, there are some issues currently, and have been some issues currently, with respect to exceedances of the 2L groundwater standards beyond the compliance boundary at the plant. And Ms. Bednarsik told me that, of course, in consequence of that, the company is required under the 2L rules to undertake monitoring and assessment activities to prepare corrective action plans and work through the agency on how that would be done, and then to implement some corrective action. And my questions to Ms. Bednarsik were to the extent that those activities would have been required by of the company, even if the company were not being required to close the ash pond at Roxborough under CAMA and CCR. Those would be required under the 2L rules, regardless of whether the ash pond was being closed, continuing in operation, or just staying in an indefinite state. And I asked her the question of whether she was able to break those costs associated with the corrective action requirements beyond the compliance boundary, to break those costs out separately from the ARO costs associated with closure of the basins. And she said that would be a better question to ask you. So I'm doing so now. Are you able to separately provide information as to what costs the company is incurring in consequence of the remediation of groundwater exceedances beyond the compliance boundary at the Roxborough plant? And distinguish those from costs associated with the closure of the basin.
I don't know off the top of my head. We have our coal combustion products finance team that's involved day to day in tracking all the costs associated with these activities. I would need to check with them to see in their records if they have a way of separating those costs, and we can certainly do that for you. I'm afraid I don't have an answer today. I don't know.
Okay. Mr. Mars, I'm going to leave that as a late file request as well.
Yes, Commissioner Kleinfelder, we'll work on that.
Finally, I want to ask one question, Mr. Riley. Are you there?
Yes, Commissioner.
Okay,
I'm here, Commissioner.
Mr. Riley, do you agree that the rate-making treatment or rate-making characterization of an item of expenditure by the company may be, depending upon the law and precedent in a particular jurisdiction, may be different from the accounting characterization of that expenditure?
I would respond by saying, well, and I believe that this was discussed yesterday. The commission is not bound by accounting. The commission sets rates, but the company is bound by the accounting rules. And so to the extent that the commission makes a determination, then the company must react to that determination in the context of the accounting under its books and records. And part of that may include a consideration of ASC 980, which is regulatory accounting, whereby the commission may not allow the current recovery of costs, but may allow it to be recoverable in the future. And as such, the company can defer recognition of expense via recognition of a regulatory asset to match up the revenue and the expense, the expense, I should say, to the revenue recovery in the future.
Well, I follow you on that, but I was actually probably asking a slightly different question. Let me put it this way. If the law of North Carolina says that I am to determine whether something is or is not property, plant, or equipment, then my guidance for determining whether or not something is property, plant, or equipment comes from statutory language, from case law, and from prior precedent of the commission. It does not necessarily come from or necessarily follow the accounting characterization. Is that correct?
I would say that is correct. I would elaborate by saying, and I do use this in my practice when I talk to others that I work with, other clients, other people within our practice. The commission cannot dictate GAAP. The commission dictates rates.
Exactly.
And so if the commission were to look at something and say it is not capital, and in fact, this is off topic, but a good example of this is flow-through treatment of taxes, which happens in some states, not all states. But the example there is that the commission prefers flow-through treatment of taxes. I'll go with my example, such that tax expense is not recognized for rate-making purposes for the benefit of effectively flowing through that benefit, lowering rates to customers currently. But the commission cannot dictate GAAP in that a regular tax liability must be recognized, and therefore it gets back to what Witness Doss talked about yesterday and today. The company must make a determination what is the offset to that accounting entry? Is that amount that's going to be recoverable? Is it an amount recoverable in the future from ratepayers? And therefore, can they record a regulatory asset? So the key point there is that the commission, as I'm just complete my thought, the commission dictates the rates, the company determines the accounting consequences of those decisions.
I follow you completely, Mr. Riley, but again, my question was slightly different, and it actually was the converse of the statement you made. I understand completely the commission does not determine GAAP. My question was a different one to you. If what the commission must determine by law is what constitutes property, plant, and equipment, the statute says we must do that, then GAAP does not necessarily dictate that determination under North Carolina law, does it?
I would agree with that statement.
That's all I have. Thank you.
Commissioner Clodfelter? Can you hear me?
I'm sorry, I turned my microphone off.
Okay.
We're back to questions on commissioners' questions.
I just want to say I do have a question, Mr. Marzo, if you'd like me to go first. And perhaps Mr.
Ms. Force,
Grantmeyer.
we'll take you last, if that's okay. All right, Ms. Force.
Mr. Grantmeyer, did you want to go?
Public Staff Grantmeyer has no questions.
Okay, Ms. Force now. You're on mute. You're on mute, Ms. Force.
I'm sorry. I find these buttons confusing. I apologize. The last question for Mr. Riley overlaps with a question I think that Mr. Doss answered earlier. And so I have a follow-up question about the difference between rate making and accounting. And here's my question. I think you would agree with me that the costs that accumulate when a nuclear power plant is under construction would normally be considered capital costs. Would you agree with me?
Sure. Costs that are incurred that are related to constructing an asset certainly are capitalizable.
So, but at some point, if that plant is abandoned and never put into rate base, it might be under North Carolina law that it has been allowed to be booked as an operating expense instead of rate base. And in that event, you wouldn't have a lineup between the rate making treatment of the expenditures and normal accounting treatment. Would you agree with me?
Well, under your example, that actually gets into some complex accounting. There are specific rules around abandonment of plants. For accounting purposes. The company to clarify what that accounting is. If at a point in time the company would make a determination that a plant is to be abandoned, that it's probable it will be abandoned, then there's an accounting consequence associated with that. It would no longer be a capital asset, but rather the company would have to determine, is there an impairment of that asset, or is that asset recoverable from ratepayers? If it's recoverable from ratepayers in the future, then the company would apply ASC 980 and record a regulatory asset associated with that.
Okay, you've gone way beyond my ability to keep up with you, Mr. Riley, but I think we had a similar conversation in the DEC case about impairment of assets then, so I'll leave it at that. I don't have any other questions. Thank you.
Thank you. Ms. Marzo, I think we're back to you.
Yeah, just very quickly, Commissioner Clodfelter. Gentlemen, I'm just having a little mic trouble myself. You were asked some questions by Commissioner Clodfelter about generally the theory of rate making, of the county following rate making. And what I want to ask you primarily, Mr. Doss, Mr. Riley, maybe you, Mr. Riley first, is the ARO process, the structure for recovery of the ARO process. Is there a set process and framework for the recovery of AROs for regulated utilities?
So to answer your question, generally speaking, it's as we described it earlier, or I talked about it earlier, where first of all, a retirement obligation has to be identified. And when a retirement obligation, a legal retirement obligation is identified, and can it be quantified? It is quantified based on how I described earlier, and it is recorded at that point in time when it's identified and estimable, with an obligation being recorded and an offsetting asset retirement cost. And as I said earlier, the FASB was very clear that that's a capital asset. But for rate making purposes, again, there's been no cash outlay, and therefore that asset retirement cost is not included in rate base at that time, as is industry practice. In the future, when expenditures occur, it's at that time costs are evaluated for recovery and are deferred in Duke's case because they were determined to be probable of recovery by the company. And I would also say, in the opinion of the company's auditors, Deloitte, that those costs were probable of recovery, that it was acceptable to record a regulatory asset. That regulatory asset, once there was an actual cash outlay, was recharacterized as a spent regulatory asset for specific recovery from ratepayers. I think it's important to note also, with respect to when Witness Doss was talking about the theoretical regulatory asset versus the spent regulatory asset, that's a good accounting mechanism to ensure that customers are not overcharged. In other words, that they only reimburse the company for actual cash outlay associated with retirement activities.
Thank you, Ms. Rowley. And just one last question. I mean, when we look at the components of that framework, we look at 410, we look at 980, and we ultimately look at the commission's deferral process. Those are all the framework that allows for the traditional recovery of an ARO cost for a regulated utility, correct?
That is correct.
Okay, and a deferral and return on any amounts that are amortized over time, that's part of the traditional framework of that process, correct?
That's correct.
And the designation of those costs as capital is consistent with that framework, and I assume with you being a national account is consistent with how those costs are considered across the country nationally by utilities.
That is correct. Just one point that I would add: once there's a cash outlay by the company, now there has been a use of investor funds, shareholder funds. It's appropriate to allow a return on the uncollected balances to reimburse shareholders for the use of those funds. Similarly, if in the case we were talking earlier about cost of removal, if amounts are collected from customers in advance of expenditures being made, then it's appropriate to reflect that cost of removal regulatory liability as a reduction of rate base to compensate customers for the use of their money in advance of expenditures being made.
Thank you, Mr. Rowley. Commissioner Clawfelder, that's all the questions I have. I did want to raise one matter with you related to the second late filed exhibit. I believe Ms. Medarsik may be able to address that question. I don't think I was confused as you were that it might have been deferred to Mr. Doss. I think she's actually prepared to discuss that. So if you want to wait until after her cross, if you want to renew the late filed exhibit at that point, we can do it. Or you want to do it? Okay.
Absolutely. Excellent. Thank you. Thank you for that. I was simply proceeding off of the earlier information. And so if she can address it now, we won't need the late filed exhibit.
Okay. Thank you, sir.
Thank you. All right, folks, I think we're at the point where we're ready for motions relative to exhibits. Who wants to go first?
This is Public Staff Grantmeyer. The public staff would move that Public Staff Doss, Spanos, Riley, rebuttal, cross-examination exhibits 1 through 8 be introduced into evidence?
All right, we've heard the motion, and Mr. Marzo, I believe we've cleared up the issue with respect to 6, 7, and 8. So
Yes, sir.
I'll hear if there are any other objections. Hearing none, those are admitted into the record. Ms. Force?
Yes, thank you. I think that we designated the exhibit as Doss, Spanos, Riley, AGO, rebuttal, cross exhibit 1. There's a little confusion sometimes in these exhibits about whether the panel name should come ahead of the party that's introduced it. It's my understanding your preference is to have the panel named first.
My preference is for the panel name first, because then when you're searching for an exhibit later in the record, you know where the highest order of classification is the witness, then becomes the examining party, and then becomes the sequence and the number. So it's a much more logical way to find the exhibit later when you're looking for it. So you have the correct designation, I take it you're moving admission of that exhibit.
I do, thank you.
Without objection, it is so ordered.
Thank you.
All right, Mr. Jeffries, Mr. Marzo.
I'll let Mr. Jeffries go first. Go ahead, Mr. Jeffries.
Okay. Jeffries, there you go.
I don't believe we have anything for Mr. Spanos. His direct exhibit was admitted when his direct appearance was waived, and he has no rebuttal exhibits.
That is consistent with my notes also. Thank you.
Yeah, and I'd ask Commissioner Clodfelter that Mr. Doss's rebuttal exhibit, as well as his supplemental exhibit, be admitted into the record.
Okay. If there is no objection, hearing none, it will be so ordered. Okay, I think that concludes the panel presentation. Mr. Jeffries, Mr. Marzo, do you wish to have any of these witnesses excused?
Yeah, I think yes.
All right. If there is no objection, then we will excuse Mr. Doss, Mr. Spanos, and Mr. Riley. Thank you for being with us.
Thank you.
Thank you.
Okay. Let's get started on our next witness. Mr. Marzo, I believe that would be Ms. Bednarsik.
Yes, sir. We'd like to call Miss Jessica Bednarsik to the stand.
Ms. Bednarsik, I saw you earlier. There you are. Great. Ms. Bednarsik, you are still under oath. I remind you you're still under oath. And with that, Mr. Marzo, the witness is with you.
Yes, sir. Mr. Bednarsik, once again, would you please state your name and your business address for the record?
My name is Jessica L. Bednarsik, and my business address is 400 South Tryon Street, Charlotte, North Carolina.
And again, by whom are you employed and in what capacity?
I am employed by Duke Energy Business Services, and I am the Vice President of Coal Combustion Products, Operations, Maintenance, and Governance Organization.
And Ms. Bednarsik, did you cause to be pre-filed in the docket rebuttal testimony consisting of 69 pages?
Yes.
Do you have any changes or corrections to your pre-filed rebuttal testimony?
No.
And if I ask you the same questions today, would your answers be the same?
Yes.
And did you also cause to be pre-filed in this docket Bednarsik rebuttal exhibit 1 through 9 to your rebuttal testimony?
Yes.
Do you have any changes or corrections to your pre-filed rebuttal exhibits?
No.
And portions of that testimony, Commissioner Clodfelter, and exhibits for the record are marked confidential. Did you also cause for pre-filed 12 pages of supplemental testimony on August 28, 2020 in response to Commission's order?
Yes.
And did you have any changes or corrections to that pre-filed supplemental testimony?
No.
And if I asked you the same questions today, would your answers be the same?
Yes.
And did you also cause to be pre-filed Bednarsik supplemental exhibits 1, 2, 3, and 4?
Yes.
And was there a correction filed to exhibit number 3?
Yes, there was.
And with that correction, do you have any other changes or corrections to your pre-filed supplemental exhibits?
No, I do not.
Commissioner Clodfelter, at this time, I would ask that Ms. Bendarsi's pre-filed rebuttal testimony, her supplemental testimony, be entered into the record if given orally here today.
You've heard the motion. Is there any objection? Hearing none, motion's allowed.
And I'd ask that her exhibits 1 through 9 to her rebuttal testimony and exhibits 1 through 4 to her supplemental testimony be marked for identification as indicated and confidential where appropriate.
They will be so marked, including confidentiality designations as made.
Ms. Bendarsi, did you also have a summary of your testimony that you prepared?
Yes.
And Commissioner Clodfelter, Ms. Bendarsi's summary was provided to the commission and all parties. And I just asked that it be included in the record as if given orally here today.
Without objection, the summary will also be brought into the record.
Commissioner Clodfelter, per the stipulation entered into between the public staff and the Attorney General and Sierra Club on September 28, 2020, I asked that the rebuttal testimony of Ms. Bendarsic from docket number E7-1214 located, do you want me to give the following transcript sites?
Please do.
Transcript volume 24, page 125, line 1 through page 204, line 16, and transcript volume 25, page 14, line 17 through page 138, line 5, and transcript volume 26, page 12, line 2 through page 52, line 7. I also asked that the cross-examination exhibits admitted during the live testimony be moved into the record and for identification. Those are public staff and NARCIC rebuttal cross exhibit number 1 through 5 and AGO Benarsic rebuttal cross exhibit number 1, Sierra Club Benarsic rebuttal exhibit number 1, and Duke Energy Carolinas Bendarsic rebuttal redirect exhibit number 1.
You've heard the motion. Is there any objection? Hearing none, the motion is allowed.
Thank you, Commissioner Clodfelter. The witness is now available for cross-examination.
Okay. First up on my list are Ms. Yost and Ms. Luer. And I assume we've got an agreement that we can have multiple attorneys examining this one witness?
Yes, sir.
Okay, that's fine. Then proceed in whichever order you two have agreed.
Thank you, Commissioner Clodfelter. This is Nadia Luer with the public staff. Good morning, Ms. Benarsic.
Good morning, Ms. Luer.
So in your rebuttal testimony, you discussed Mr. Lucas's proposed disallowance for the cost of groundwater extraction and treatment at the Asheville and Sutton plants and for land purchases at the Mayo plant. And I'm looking on page 54 of your testimony.
I'm there.
Okay. I'm looking at lines 20 through 22, where you state that DE Progress would have installed extraction wells to comply with CAMA even without the Sutton settlement agreement. And Ms. Benarsic, that's because DEP had exceedances at or beyond the compliance boundary at both Asheville and Sutton. Is that correct?
Yes.
Okay. And if the company did not have exceedances at or beyond the compliance boundary at those two sites, neither CAMA nor the CCR rule would have required extraction wells and treatment. Isn't that right?
Just to make sure I get it right, can you please ask the question again?
Yes. So if the company did not have exceedances at or beyond the compliance boundary at Asheville and Sutton, then neither CAMA nor the CCR rule would have required extraction wells and treatments. Is that correct?
That the extraction wells and treatment were because of the exceedances beyond the compliance boundary.
Okay, thank you. And then you briefly discuss the land acquisition costs at the Mayo plant on page 53 of your testimony. And at this point, if I could have you refer to Public Staff Cross Exhibit 117. And that begins on page 3696 of the PDF. And this is a Duke Energy Progress response to a public staff data request.
I have that in front of me now.
Commissioner Clodfelter, we would ask that Public Staff Cross Exhibit 117 be identified as the NARCIC Rebuttal Public Staff Cross Examination Exhibit number 6.
It will be so marked.
Ms. Benarcik, on the second page of this document, under the heading Mayo Steam Electric Plants, the company discusses its purchase of approximately 56 acres of property bordering the Mayo plant. Is that correct?
Yes.
Okay. And that same paragraph states that the property purchase allows Duke Energy to control activities on the property, thereby managing risks to property users down gradient of the Mayo Ash Basin to the North Carolina-Virginia state line. Ms. Benarcik, what were the risks to down gradient property users that the company wanted to manage?
Well, as it states later on, there was 3 groundwater monitoring wells on the property. We did not have any exceedances of the 2L. We were not buying the property because of exceedances of 2L, based on my understanding, and Mr. Wells would be able to clarify that. It allowed us to have a little bit more room on our compliance boundary, because the compliance boundary is either based upon where your property border is or that 500-foot compliance boundary. So this allowed that compliance boundary to go a little bit further. And that allowed just a little bit more distance between where other people who own different property in proximity to our ash basin.
Okay. And so I guess going back to my question, what specifically were the risks that the company wanted to manage?
Access and having additional area for us to be able to have that larger, a little bit more of a compliance boundary. But again, not risks related to groundwater, because we had no impacts of groundwater on that property, but it was access and making sure we had more of a buffer around our basins and be able to push out our property boundary around the basin.
Okay, thank you. And those are all my questions. I believe my colleague Ms. Yost has some additional questions.
Thank you. Good morning, Ms. Bednarczyk.
Good morning, Ms. Yost.
So I have tried to organize my questions so that we won't need to get into confidential information until later in the questioning. But of course, let me know if you think that you need to touch on confidential before I indicate that we will. So I'd like to begin by discussing Asheville. And on page 187 of the Commission's final order in the E2 sub 1142 rate case, the Commission stated, the Commission determines, however, that witness Karen has lived this project since its inception and relies upon his testimony regarding the decisions he made. And it continues on. Would you say that you have lived the Asheville project from the beginning, as Mr. Karen testified he had?
Can you please give me the reference? I was opening up the last case document when you were talking. If you could give me that again, so I could just.
Of course. It's on, I believe it's on page 87.
The page 87 I have starts with the word pitfall. Is that the same page?
The page 87 I have starts prudently incurred. Let's see.
Megan, could you give the public staff exhibit number again, just to make sure?
This is actually the company's potential cross exhibit number 2. And I'm sorry, I'm looking on, I must have had a different version. Could you look on page 190, please, of that order? And it's the first paragraph on the top.
Hold a second, Ms. Yost. We've lost Ms. Bednarsik's video. We need to get her back.
I think when I went to go pick the binder up, I must have hit the mouse button. So I now have I had a couple different versions of the order. So I now have the company's potential cross exhibit number 2.
Great. So if you could turn to page 190, please. And I'm looking at the page number on the bottom, which is also for the PDF I have, page 190 of the PDF.
Just to make sure, so 190, I have it starting off, the first word, new generation?
No, I have CEG 1988.
Meg, if you could tell me the reference that you're looking for, I'll try to see if I can find it. I think the pagination was off yesterday with Mr.
Okay.
There may be an issue.
Oh, I wonder if this was the result of maybe a corrected being filed. In any case, I'm looking again at page 190 of the commission. That should be the number of the commission's order, the page number of the original commission order, I would imagine.
Ms. Yost, this is Kiran Mehta, yes. And I think at least on the electronic version of Company Exhibit 2 that I have up, the page that you are referencing is page 187.
Okay.
For some reason, the PDF is page 190. I do not know why.
All right. So maybe try page 187, which is, I think, the number I originally gave. Ms. Bednarsik, when you get there, is that to begin CEG 1988?
Yes, actually, someone came in and put it in front of me, so I am on the right page now.
Super. So if you could, the sentence I was referencing is the sentence which begins about midway down that first paragraph. The commission determines, however. Do you see that sentence?
Yes, I do.
All right. So again, the order states the commission determines, however, that witness Karen has, quote, lived, unquote, this project since its inception and relies upon his testimony regarding the decisions made. And then it goes on. Would you say that you have lived the Asheville project from its beginning, as Mr. Karen is quoted as having stated?
Well, I have not personally been involved with the Asheville project since it began. I have had numerous discussions with people who have, and so been able to get up to speed and understand the decisions that were made at the time they were made, with the information made available to them at that time.
All right, I'd like you to turn to page 29 of your rebuttal testimony, please. And if you could just let me know when you're there.
I'm there.
All right. And beginning on line 5, you discussed Mr. Karen's testimony in the sub 1142 rate case that a 3 million ton on-site landfill was technically infeasible. Is that correct?
Yes.
Do you agree that Mr. Karen's conclusion was made without the benefit of an evaluation to construct an on-site landfill to permanently store the remaining ponded ash and production ash after CAMA was passed in 2014?
So my understanding, talking to Mr. Karen and also others who have been involved in the project, is that the 3 million landfill was not feasible to build on site. And for multiple reasons. As you know, we are building a landfill on site right now for a 1.3 million tonnage landfill. And that's an area that was not available to us beforehand. And there was previous studies of looking at landfills potentially on site, specifically in the location of the 1964 basin. And there was concerns related to the availability and the ability to construct a landfill in that area because of the dam itself, some concerns from regulatory agencies, some springs in the area. So all of that information and that we knew about the site went into the decision of, could we do a 3 million ton landfill on site, knowing what we know at this time and the areas we have to utilize at the time to be able to continue operating the plant.
And were these studies you're referring to done after the passage of CAMA in 2014?
So the studies I was referencing were studies that were done earlier when the plant was operating, and they were looking at, because the company always does pre-planning on, we need to make sure we have enough room to handle the ash. So there are studies that were conducted to say if we are going to run out of room, and based upon what they know at the time of how long the plant's going to operate, they look and go, what are the options we have available to make sure we can handle the ash appropriately, and that we have enough room on site, off site in order to manage it. So one of the things that was looked at was a landfill on site. And I also believe at one time they started working through a potential putting a landfill in the area of the 64 basin, and the local Buncombe County Zoning Board had brought up concerns of having a landfill in that area, especially as close to the highway and with where the dam was, and being able to move forward with that. So while a specific study was not done in the time frame that Mr. Karen was referencing, we did have knowledge based upon past examples or past studies, past discussions with regulatory boards. And so Mr. Karen, what he said in 2015, we could not put a 3 million ton landfill on the site.
And so these studies that you're referring to, did those assume construction on top of the existing ash in the 1964 and 1982 basins or off-site?
I'm going off of memory here, and yes, I believe they looked at off-site locations and also building a landfill on top of the basins that were there.
All right. Do you agree, getting back to Mr. Karen's conclusion, that it was made without the benefit of an evaluation that took into account the 2015 passage of the Mountain Energy Act?
So you are referencing something specifically with Mr. Karen and—
Yes, his testimony that a 3 million ton on-site landfill was technically infeasible. I'm asking, was that conclusion made without the benefit of an evaluation that took into account the passage of the Mountain Energy Act in 2015?
Specifically as to the Mountain Energy Act, I did not ask him that specifically with the Mountain Energy Act and looking at it, but I do know that with the Mountain Energy Act, of course, we had to continue operating the Asheville plant. We were allowed to have a few more years in order to close the basins. So we have to close the 64 basin by August 1st of 2022. Also, with the Mountain Energy Act, we had to continue operations of the coal plant. The operations of that coal plant ended at end of January of this year. So looking at, we had to manage the ash for that plant that was still operating. And that was going, that ash that had to be managed, that had to be dried, had to be, we had to do something with it. Well, of course, we were generating ash. That happened inside of the 1964 basin while we were removing some of the material and sending it for offsite disposal. So maybe I'd say I'm not quite sure where you're getting at, other than we had to, of course, continue operating the plant. We continue to have a place to place the ash on site. And if you look at constructing a new power plant, operating an old power plant, excavating some of the material, trying to do all of that on the small Asheville site, that there was no way we could build a 3 million ton landfill on site on that site at all.
Well, okay, what I was getting at, my question was there an evaluation done after the passage of the Mountain Energy Act?
An evaluation was not done because there was no way we could have, I would say, based upon what I know, talking to the people at the site, visiting the site while all that work was going on at the same time, we could not have built a landfill at that site during that time period.
And would you also agree that no evaluation was done in 2016 or 2017 prior to the commission's decision in the last rate case and the construction of the combined cycle plant?
The decision to build the 1.3 million ton was made in April. I think it was April of 2019 is when we determined that we were able to build a much smaller landfill in the location where the laydown area was for the combined cycle. So that decision, that evaluation happened in the late 2018, early 2019. It was April 2019 when it was determined to move forward with that smaller landfill.
And in making those determinations, isn't it true that the company was continuing to rely on an evaluation, done in 2017 for a much larger landfill that was intended to store production ash on top of impounded ash stored in the 1982 and 1964 basins?
No, so the decision in April of 2019 of being able to put a landfill on site of 1.3 million tons in the area where the laydown area was, it's outside of the basin. We could not build a landfill inside of the 1982 basin while operating the combined cycle. It's a very small footprint. We actually are going to, in a couple of our sites, build a landfill inside of a basin. For example, at Allen, that's one of the things that we have submitted to the state. But in order to do that, it's a much bigger basin. And we are having starter landfills even outside of that basin in order to help us get started. So when you look just physically at the acreage that you would need in order to try and even start a landfill inside of a basin while operating a coal plant and trying to manage that ash while building a combined cycle on site, that's a recipe for accidents. I mean, really physically, there was no way, small basin, to build a landfill while all those other activities were going on in the ash basin.
Okay, so again, my question is, did the company rely on a 2017 study or 2007 study?
We did not rely upon a earlier study. What we relied upon was physically being able to execute work within that basin. And also knowing that there were springs, knowing that in order to build a basin or a landfill inside the basin, you would have to excavate the ash and put it on a lined something or other in order to do that. So again, physically, we did not have the space on site while all that activity was going on to do a landfill inside the basin. So a study was not needed to make that evaluation.
Okay, let's move to page 28. please. I guess it's going back by one page.
Ms. Jost,
Yes.
since you're moving to another part of the document, let's take our morning break if we can.
All right.
If that's okay with you.
Yep.
Then we will come back at 11 o'clock.
Commissioner Hughes, can you turn off your video, please? Thank you.
John?
Yes.
How's it going? I put in the ear pods. I think it's working, but I'm not sure.
Yeah, I don't hear any background noise or anything like that, so I think you're good to go.
Well, right now, of course, the jackhammers have stopped.
Of course, it never fails.
So, but at least this is working, and hopefully that's better than my camera microphone. So
Okay.
I think I've done what I can do. Thank you very much. We'll just pray that the jackhammer stop. Thank you.
All right, no problem.
Folks are drifting back in. I can tell it's Friday. Okay. Joanne, are you ready to go? All right. Ms. Jost, we're back with you.
Thank you. Ms. Bednarsik, before we move on to your page 28, just a couple of follow-up questions on that last line of questioning. You had indicated in response to my last question that a liner would have to be put down before ash was moved and that there wasn't enough room to do that on the site. Is that right?
Yeah, so in order to build a landfill inside of the basin, we would have had to, of course, move the ash out of the way. Not enough room inside of the basin to move it, to dry it, and you can't move it and place it on just soil. So a requirement of I can't remember if it was CAMA or CCR, but if you move it, you have to place it on a liner, and so you might as well build a landfill. And again, the only place that we had available was being utilized as the laydown area.
Would you agree that the size of that 1964 basin was about 46 acres?
Yes.
So are you saying that the company couldn't have done a phased excavation where they would excavate ash, stack it within the basin, and then line the fully excavated sections and then replace the compacted ash back into the lined sections?
That's it. We could not do that. I lived that site while the work was going on for the excavation, the handling of the ash that was being produced at the power plant, and the construction of the cycle and the laydown area. There was not enough room to do all of that. It was physically impossible. And anyone who actually visited the site while all that work was going on and seeing what you would need and the volume of the area you would need to do all of that, it could not be done.
Did the company evaluate the possibility of leasing land near the site for the laydown area and parking and shuttling employees back and forth to the site to make some more room available?
I do not, that would have been done by our construction organization, and I did not review any documents, so I would not be able to know whether that was evaluated or not. But we did, of course, have the area on site that we were able to use for as a laydown area. I would also say that in Mr. Garrett's, he used one of our data requests as part of his testimony. His data request number 13, or not data request, his exhibit number 13 actually lays out a number, it was a response, of course, from the company, that laid out a number of concerns related to doing anything inside of the 64 basin. And it talks about things such as the proximity of the proposed over basin landfill. The Buncombe County Zoning Board was concerned about the proposed landfill's proximity to the French Broad River, given the seismic risk. So that was another thing, looking at building any type of a landfill inside of specifically the Asheville 64 basin. And then the answer also on the second page of our response to question number D, the 64 basin is not being used to site a landfill primarily because such use would require double handling of the material and temporary out of the basin stockpiling of material. And then later on, in order to build and operate a landfill in the basin, ash would have to be stored outside of the 64 basin in a lined facility, and the in-basin landfill built, stormwater control features built, and the dam partially decommissioned before a landfill could be operated within the basin. So there's lots of things that we looked at. While we may not have done the study, people who were on the site looking at it, knowing the constraints on site, said that there is no way we can do all that we need to do on the Asheville site to be able to execute the work appropriately. And again, I visited that site, saw it, and went, my biggest concern when I visited was, oh my goodness, so much going on. how are we making sure people are safe? So adding in a construction of a landfill does not make sense. Did not make sense, which is why we did not do it.
The seismic concerns that you just alluded to, that was related to a plan that would have construction on top of existing ash, isn't that correct?
The seismic concerns with it was on top of the ash. Yes, that was one of the concerns. But also where that dam is located, and it's where we are building the new landfill is on native ground. And we are doing things like a mechanically stabilized wall, adding more beef, I would say, to landfill to make sure that it is meeting all the requirements of the state and the zoning boards. So all of that goes into why it was okay, and we did move forward with a 1.3 million ton landfill in the area where the laydown area was, and why we cannot put in a landfill inside the 64 basin.
All right, let's move on to page 28 of your testimony, please. Starting on, let's see, line 10, you state the maximum capacity of the on-site landfill at Asheville currently being constructed is 1.3 million tons of CCR, is that correct?
Yes.
That is based on the company's needs as of 2019 and the location that the company selected. Is that correct?
So that is based upon the area that is available on site to do an on-site landfill. That is the biggest landfill that we are able to build. Actually, we are, it's smaller than what we need. And we were able to luckily find a cement kiln that is taking, I think it's between 70 and 90,000 tons. And we may end up sending more to them in order to make sure that we can fit the remaining ash on site. So the 1.3 million tons fits what's left on site. And a little bit extra has to go off site, and we found a beneficial use for that.
On page 31, starting at line 7 and continuing through the next page, you present a quadrant evaluation of the site. Is that right?
Yes.
And am I correct that that was prepared specifically for your rebuttal testimony?
Yes, and it was only prepared to help be able to explain the site constraints on site and all the activities that were going on at the same time.
All right. I'd like to move now to some questions about beneficiation. If you could please turn to page 45 of your rebuttal testimony.
I have that in front of me now.
Great. Do you agree that footnote 7 on that page states, quote, Mr. Moore suggests that CEFA expended only $40 million on capital costs for the Wynya station. From what I can tell, however, his cost analysis is based on a single 2013 article from Waste 360 that neither provides a source for this number nor gives any specificity as to what costs were included/excluded in the 40 million number. Is that a correct reading of the footnote?
Yes.
All right. Commissioner Clodfelter, I would request that Public Staff 138, this was one of the potential cross exhibits, be marked Bednarsik, Public Staff Rebuttal Cross-Examination Exhibit 7.
It will be marked as Bednarsik Rebuttal Public Staff Cross-Examination Exhibit 7.
Thank you. And this is a document that begins on page 4198 of the public staff's combined potential cross-examination exhibits. And I'm going by the number on the center bottom of the page.
Ms. Jost, I was trying to find my book. Can you
Sure.
the exhibit again, please?
Yeah, it's Public Staff 138. So this is in our packet of potential cross exhibits.
I have that in front of me now.
Okay. Do you agree that this appears to be a presentation by CEFA about star beneficiation process byproducts utilization? And the name is on there is Robert Irwin, who's identified as project engineer with CEFA?
Yes, I do see that's what the document states.
All right. And do you agree that the web address for the document that's printed at the bottom includes the year 2014, or it states 2014 star beneficiation project process byproducts utilization?
Yes, that is what is written at the bottom of the document.
All right. If you could please turn to page 4219 of that document. All right. Do you agree that the first bullet point on the top slide states the CEFA Group is building a $40 million facility to recycle high carbon fly ash produced by the power company Santee Cooper at its Winya generating station in Georgetown, SC?
Yes, that is what that first bullet does. It says it's building, but what I don't know is off the top of my head when that project was completed, what was included in there, and what the final price tag was. But it does say that they is building a 40 million facility.
All right. On page 46 of your rebuttal testimony, I'm looking at lines 14 through 17.
I have that in front of me.
Great. You state, quote, in fact, however, CEFA Vice President William Fedorka has provided a sworn affidavit in this case, confirming that the Winya facility has only designated or was only designed to produce 250,000 tons of ash. Is that correct?
Yes.
And that affidavit was attached to your rebuttal testimony as Exhibit 8. Is that correct?
Yes.
And do you have that in front of you? Because I am going to ask a few questions about it. Great. Do you agree that paragraph 5 of the affidavit states, quote, based on an assumed average loss on ignition or LOI factor of 9% for dried feed ash introduced to the Winya Star, the annual feed ash tons to be processed by the Winya Star would be approximately 275,000 tons under the original 250,000 ton designed specification and approximately 300,000 tons under the revised 275,000 ton design specification.
That is what's written in his sworn affidavit, yes.
Thank you. Do you agree that the term to be processed in the context of that excerpt means input?
Yes, so you of course put more in and then what you get out at the end of the process.
And if you could look back at what we marked as Bednarsek Public Staff Rebuttal Cross Exhibit 7, that's the slide deck. Do you agree that the third bullet point on the top slide states the new facility is expected to recycle up to 400,000 tons of fly ash per year?
Yes, that is what is written in the PowerPoint presentation, but that is also why when we went back to CEFA and they provided the sworn affidavit in order to clarify what we saw and going back to the request for information that we had received had slightly different numbers in it as well. So that's why we went back to CEFA and said, can you come up and let us know exactly what happened at the Winya site? And that is why Mr. make sure I get his name right, Fedorka, provided the sworn affidavit to make sure there was clarity as to what was constructed.
Would you agree that the response to the RFI, as you just said, included different numbers, that those numbers were also higher in terms of the capacity to process than Mr. Fedorka's affidavit would indicate?
If you're talking specifically what was in the RFI related to the Wynya site and what was there, yes, it was different than in the sworn affidavit, which is why we, again, went back to Mr. Fedorka and said, we want to make sure that we 100% understand what's going on with the Wynya site, and he provided the sworn affidavit.
And more specifically than different, those numbers were higher. The affidavit indicated that the facility, the Wynya facility, could process more ash than Mr. Fedorka's affidavit stated. Is that correct?
I would have to look at the RFI specifically to make sure that the numbers, I don't have all the different numbers memorized, but that's, I do know Mr. Fedorka's affidavit was his sworn affidavit. And that's why we went back to him and said, can you look at these numbers again? Because this is what we saw in your RFI. This is what we've heard from you as we construction and we visited the Wynya site. So that is why we went back to him and got the sworn affidavit.
All right. Let's move on to some questions about the chara fulfillment fee, which you discussed beginning on page 18 of your testimony, I believe.
I'm there now.
Okay. Just a moment. I just realized I have a wrong page reference, so bear with me for just a moment so I can find the correct page. All right, if you could, actually, just taking a step back, look at page 15. And I'm looking specifically at beginning at line 11. And here you are discussing the allocation of prorated costs to the Sanford site, despite the fact that no ash was sent to that location. Is that right?
Yes, we ended up not sending any ash to that location.
And so on line 11, beginning at the end of that line, you state, in any event, costs related to Sanford make up only approximately 12% of the total fulfillment fee. Is that correct?
Yes.
And do you agree that 12% of 80 million is $9.6 million?
I would say I can't do that math in my head, but subject to check, I would say that sounds about right.
Is it your position that 9.6 million is an insignificant amount of money?
So the Sanford site had costs associated with it for purchasing the property, and it's a mine site, and there are requirements in that mine property. And that was what was included in the, when we did the prorated percentage and received from Chara and our evaluation as well, looking at the projected costs to manage what was needed at the site. That is what came up, was the 12%. So whether it's significant, insignificant, it is what it is.
All right. I will need to move to confidential, or I believe my questions will elicit confidential information at this point. So I believe we'll need to move to the phone line.
All right, Ms. Jost, let me ask you this question before we do that. Do you have other lines of questioning for Ms. Bednarsik that we will take up that will be non-confidential?
No, I have tried to, excuse me, organize my questions so that the remaining ones will touch on confidential.
Okay, that's great. Thank you. Then at this point, everyone should keep your connection, your WebEx connection open, but you should mute your mic and turn off your video. Mr. Robinson, I don't know whether the number has been recirculated this morning, but probably wouldn't be a bad idea if to do that. And sure. And let's give folks about 5 or 6 minutes to call in before you start the roll call. And so let's actually resume on the phone at 11:30 a.m. That should give everybody time to get to their phones and dial in. Okay.
Thank you.
Anything else we need to do before we leave the WebEx video and go to the confidential phone line? Okay. 11:30.
John, out of abundance of caution, would you double check me, please?
We do hear you, Miss Crowley Jones.
Thank you. I appreciate it, Commissioner Franklin.
Okay, we are now back on the WebEx video and audio connection. The confidential portion of the cross-examination has concluded. Ms. Yost and Ms. Luer, I understand there's no more cross-examination from the public staff. That being the case, we'll now take cross-examination from the Attorney General's office. Ms. Townsend.
Thank you, Commissioner Klaffelter. And good afternoon, Ms. Benarsic.
Good afternoon, Ms. Townsend.
First of all, I want to advise the commission that we are party to the amended joint stipulation that was identified by Mr. Marzo during the introduction of Ms. Benarsic. In a review of my notes, I discovered that during my direct, I inadvertently failed to introduce into evidence the Mayo April 1st, 2019 closure determination done by DEQ, which is pre-filed as AGO Exhibit 17. And we would like to mark that, Commissioner Klaffelter, as Benarsic rebuttal AGO cross exhibit number 2.
It will be so marked.
Thank you. Now, if you would, Ms. Benarsic, turn to the document that we attempted to discuss at the end of our directed testimony, which was Hart 38, and which we then marked and omitted as Benarsic Direct AGO Cross-Exam Exhibit 28. Do you have that in front of you?
Ms. Townsend, I have it actually up on the screen so I can see all the tabs.
Perfect. Thank you very much. This is a what they call significant scoring matrix, which is evidently developed by DEP in 2012 to evaluate the priority of plant environmental impact issues. Would that be an accurate assessment of the purpose of this document, Ms. Benarsic?
That is my understanding of the purpose of the document, yes.
Okay. And during your historical review of the environmental issues at DEP, did you review this document?
I did. I remember looking at it one time, and I remember looking at one time, but did not spend a significant amount of time with it.
All right. So let's go to the document, and if you would please go to the tab marked Priority Ranking Chart. It's to the left of the sites themselves.
I am on that tab.
All right. And that tab has a matrix, does it not, showing the various levels and what levels would be which priority. Is that correct?
Yes, this is a standard type of a risk matrix.
Right. All right. And so we see that 1 through 7 is the lowest priority, 8, 9, low priority. Whoops, we lost you. We lost your video, Ms. Benarsic. You there? Okay. And then 10 through 13 was moderate priority, and 14 to 25 is high priority. Is that as you understand the matrix to be?
Yes, that is what the matrix states.
Okay. And if you would now go to the tab where we find the key to the significance rating, and I believe it's tabbed as scoring criteria. All right. And
Commissioner Klaffelter and Ms. Townsend, I'm sorry to interrupt, but we're lost on your document. Can you help us find where you are in the documents?
Yes, if you've got the electronic version with the tabs, is that what you have?
Well, tell me which document and then
Oh, I'm sorry. The document is Hart 38, which,
right.
Yeah.
Okay.
Okay.
Right, and then tab.
And then the tabs, and you'll see when you first look at it, the tabs show you the sites, but if you go left, you'll find the tab marked priority ranking chart, and further left, the scoring criteria. Do you see those tabs?
I'm not sure I'm seeing tabs, but I think I'm find it. So what was the category again? You said I'll see.
Right. The one with the matrix on it is called priority ranking chart.
All right. That should be good. I'll find it.
Okay. And the other is scoring criteria. Those are the two identifying elements are reflected in the actual matrix for each site. So
thank you.
You're welcome. Sorry for the confusion. If we go to the key to significance rating, Ms. Bernarczyk, we won't go through this whole document, but what I would like to do is just very briefly, for instance, the first, I guess, column is likelihood. Do you see that?
The first grouping is likelihood, yes.
Grouping is a good word. All right. And so the rating of 5, let's just talk about the 5s, and then we can look at the actual ratings if we need to for the others. But likelihood for a 5 means that it's very likely, high probability, 90% or more that an aspect will result in the described impact. Is that how you understand it?
That is what the document states.
Okay. And then the next column evidently is exposure/toxicity. Okay.
Yes, that is, and if you look in column A, it has, those are all kind of grouped together for consequence.
Right, right. And again, for 5, is the severe impact is catastrophic, very harmful, potentially fatal to humans and or large portions of the ecosystem, right?
Yes.
Okay. And if we go to the business risk cost, their 5 is the major impact is over $1 million. Is that correct?
Yes.
Okay. And public relations cost, 5 is primary concern to most stakeholders. Correct?
Yes.
Okay. And the last one is regulatory. And 5 stands for government, fines and or criminal activity, impact reportable to state, federal, or local authority, and involving criminal activity, NOV issued and or fine likely. Is that adequately express what that 5 stands for?
Yes, and it's probably good to note that, as you could tell, some of those are prescriptive, some are subjective, some actually have like the dollar amount is a dollar amount, but some are based upon the people who are doing the evaluation, their perception of what it would be.
And who would have done this evaluation for DEP back in 2012? Who would have been responsible for putting it together?
Based upon the conversations I had with people who currently do these type of evaluations, even today, it would be a combination of site personnel that would include the station manager, the site environmental consultant who was stationed at the location, as well as other subject matter experts and plant personnel.
Thank you. And if we go to the first site, which is Asheville, are you there?
Yes, I am there.
Okay, and let's talk about what at this time the 5 top significant environmental impacts, which are indicated on these documents prepared by DEP. And if you would, if you could tell us what the first one is at Asheville.
The first one is power plant operations is the primary activity. Secondary is control equipment and monitor operations. And the
you don't need to worry about the aspects, just
okay.
Jump over to potential impact will be great. Thank you.
The potential impact is positive reduction of air impacts.
Okay, and evidently that was a strong concern because it was 5s all the way across. Is that correct?
That is what the document indicates.
Okay, and do you know any differently?
I do not have any knowledge related to the air, that what specifically is on that line.
Okay, let's go to the next line and just go to the potential impact, if you will, to save us a little time. And what is the second most, whoops, we lost you again, Ms. Bernarczyk. Whoops.
This is the problem when you have two screens and you go off on the screens. So I'm sorry about that.
No, that's totally understandable. So the second impact, or the second significant impact at Asheville in 2012 was, it says pond potential groundwater impacts. Is that correct?
Yes.
Okay. Now that doesn't have all fives, but it shows 5 for likelihood, 3 for toxicity or exposure, 5 for cost, 5 for PR, and 4 for regulatory. Is that correct?
Yes.
Okay. And the next one, number 3, is what?
Is groundwater impact.
Okay. And it appears to have the very same rankings as the second one. Is that correct?
Yes.
Okay. And number 3? I'm sorry, 4?
Mr. Chairman, I'm just going to object to the extent. I mean, we're just going to read the numbers. If this, to the extent it's a Duke-generated document, we'll stipulate it says what it says. If there's questions related to each category, that's something different.
Ms. Townsend, you have a proposed stipulation from the company that the document is admissible and says what it says. How do you respond?
I have no objection to that. That's fine. And we can shortcut everything and I will be done with all my questions.
You have on this document or on any other document?
On this document, and the only question I would have is based on looking at all these questions, you will find, Ms. Benarzik, will you not, that obviously ash management concerns and groundwater impacts were one of the 5 top for every single site. Would you agree that that's subject to check based on it being your document?
I have not looked at every tab, but the document states what the document states.
All right. Then with that, I have no further questions. Commissioner Clawether.
Thank you, Ms. Townsend. Ms. Crawley-Jones?
Good afternoon, Ms. Benarzik. We're getting close at the end of this marathon. Commissioners, I would also note that Sierra Club is a party to the stipulation, and so questions will focus on those issues new to the DEP plans. Ms. Benarzik, on page 7 of your testimony, you discuss company actions relating to basin closure. As part of the company's closure of its ash ponds, the company has undertaken the rerouting of processed water, stormwater, and other non-CCR waste streams that have been sent to the ponds. Is that correct?
Yes.
Would it be fair to say that stormwater represents the bulk of the volume of wastewaters being rerouted?
So I would say it depends upon the plant. Of course, the bulk of the material that went to the ponds was the sluiced ash and the water that came from the sluiced ash. The storm water that is directly that we had to reroute and move away. Of course, not the rain that comes down or what we call sheet flow, that is just from the gradual sloping of the area around there into the pond. The stormwater was channelized flow. So any stormwater that hit what I like to call is hardscape, is anything that didn't hit the ground, the soil, but hardscape inside the power block itself, was all channelized out to the ash pond, because the ash pond, of course, was our treatment system. And all those streams were in the NPDES permit as a permitted stream to go to that treatment system. So I would not say stormwater was the bulk. It really depends upon the site itself. Really, the bulk was the sluiced ash.
Okay. But at each of the ponds where closure's taken place, there had to be some rerouting of that stormwater flow, correct?
So at the ponds that had active operating power plants, yes, because that was, again, that channelized flow from the power block, from the hardscapes of the power block could no longer per the CCR rule and CAMA go to the basin. So that is why we ended up constructing things called like line retention basins. Those were our new treatment systems. And if they were moved that way for to make sure we can continue to provide safe, reliable electricity, then that was a capital cost. Now, for the sites that were retired, Cape Fear is a great example. Those channelized stormwater lines, of course, were taken out when those power plants were retired. And so therefore, we did not have to do any stormwater reroutes around the Cape Fear. Some locations where we may have continued to use the basin for combined cycle, and it was continued to use as a treatment system for the combined cycle. Sutton is a good example. Of course, then we would have had to reroute those channelized water lines that went into the basin.
Okay, so I want to make sure I caught up with you. So where the rerouting has been completed in many of the plants, that was rerouted to newly constructed line retention basins, correct?
Yeah, so again, the NPDES was related to the fact that the basins were our treatment system.
Right.
Since we were no longer allowed to use them as a treatment system, where we needed to, all that hardscape and that stormwater, where it had to go to a new treatment system, those of course were constructed and are in operation.
And if there are any ponds where rerouting has not yet been completed, will that also be sent to newly constructed lined retention basins?
So all of those activities are complete. They had a date certain. I would have to look up the date, but we had to meet dates to have all those done, and those have been completed.
Okay. And those lined retention basins are located on property that is already owned by the company, correct?
Yes.
Great. All righty. Now I wanted to go to page 61 of your testimony, where you are discussing that DEP's coal ash management practices, in your belief, were consistent with industry standards at the time. And on that page, on lines 11 and 13, you criticize witnesses Lucas, Hart, and Quarles for relying on, quote, a small handful of papers published between 1967 and 85 to call into question the prudence of the company's use of unlined ash basins. So is that a good summary of kind of that piece of the testimony?
Generally, yes.
Okay. Do you consider the historical documents cited by intervener witnesses relevant in a determination of what industry standards were?
I think that they're historical documents, and there's a lot of information that is out there. But I also would like to say that documents are a few documents here and there. You can't cherry pick, and you can't cherry pick a few documents. You can't cherry pick a few lines out of documents. One of the reasons we also look at it and say this is historical practices. I would like to bring up that the way Duke Energy is today, of course, is not what Duke Energy was in the 1980s. So another way you can show that the historical practices, that we were following industry practices, is that Duke Energy Progress and Duke Energy Carolinas merged in 2014. We followed the same historical practices before we were one company back in the day. Also, Duke Energy Carolinas and Duke Energy Indiana, we merged in 2000 and I have to go back through my mind, 2006. The practices of handling coal ash in the legacy Duke Energy Carolinas practices and the Duke Energy Indiana were exactly the same. Duke Energy Indiana merged from two companies, Cincinnati Gas and Electric and Public Service of Indiana. Prior in the 1980s, 1990s, before they merged, handled coal ash practices exactly the same. So I would say that the industry documents are good. They're a piece of the puzzle. They're not the whole puzzle. And being able to look at industry practices from people on operations, and I just mentioned the companies that are now Duke Energy, not let alone the other companies that I talked to there in my peer group, neighboring companies. All of that needs to be taken into account when you look at historical practices. So again, documents are good. They're one piece of the pie. They are not the be all end all.
Okay. And on page 62, line 7, you again criticize the interveners and Mr. Lucas as their points were viewed through a filter of a 21st century lens when, quote, no such clarity existed in real time. Is it your position that the company had no clarity regarding operation of any of its ash basins until the adoption of the CCR rule?
No, ma'am. That I think you're mischaracterizing what is meant there. What is meant to say is that the company has to make decisions based upon what is known at the time that the decisions are made. So, of course, what we know today about coal ash and about groundwater has evolved over time. And I believe Mr. Wells and Ms. Williams are great people to talk to about this. And they provided also in DEC the history, how things have progressed over time. So what that comment meant is that you can't go back and look at the what ifs. What if we knew today what if we knew back then what we know today? When I've read through the intervener's testimony, that's what came out to me, is that they were applying knowledge of today and reading these historical documents and going, well, of course. And that is not what you really need to do. You need to go back and say, how can I take away what I know today and determine if the company made decisions based upon what they knew at the time that they made those decisions. That is very difficult to do. And I mentioned that, discussed that in the DEC part of the testimony, but that is what I meant here is when I reviewed their testimony, they were putting today's lens, what's known today, when they try to look at the historical practices. And that's what I was calling out.
Are you aware that in 1978, at the time the company was making decisions, EPA had clearly stated that water carriage of fly ash and bottom sluicing systems are, quote, inconsistent with existing and expected standards of performance for new sources?
Ms. Crawley-Jones, that would be a better question for Ms. Williams. And also Mr. Wells. I know that there was, I think in one of the documents, I read that one line item, but I would also say that, again, that's one item out of lots of documents. You really have to look at the history of what was going on at that time. So I would say, please talk to Ms. Williams and Mr. Wells about that specific item.
Okay. Well, let me also ask you, let's look together for a minute at what has been marked as Sierra Club Potential Cross Exhibit 22. And Ms. Bedarsnik and commissioners, this is that large document that was filed in 4 PDF sections. It was the company's response to public staff data request number 57, and it was more than 500 pages long, provided by DEP in these 4 separate files. And I believe those have been made available to everyone. And we'd ask that for completion, the company asked that the whole thing be marked or available. So we would ask that it be marked for the record as Benarsic Rebuttal, Sierra Club DEP Cross Exhibit 2.
It will be so marked.
Okay.
Ms. Crawley-Jones, can you tell me that number again? I don't know if I have the right one in front of me.
I think you're going to need a digital document. I'm not sure how it's been provided to you. It's potential cross exhibit 22, and it was named as the Mayo 1977 EIS, and it's in 4 parts.
Mr. Marzo, I believe this is the exhibit, potential exhibit that the commission authorized to be served in electronic form due to its length. Can you help Ms. Bednarsik locate it?
That's correct, sir. Let me see if I can help her find it. If I could just have a couple of minutes.
All right. I tell you what, just so we're clear about that, and I need to do one other administrative matter anyway. It's 12:25. Let's go ahead and take our lunch break. That way you can make sure Ms. Bednarsik has the document, that everyone else who wants to have access to it can get access to it. And we'll take our lunch break and come back at 1:30. Before we actually leave, Ms. Townsend, I want to be sure we've got for the record the last document you were using with Ms. Bednarsik. I want to be sure we got it identified and marked correctly. I understand the company is going to stipulate its admissibility, so you don't have to worry about there being an objection to it, but I want to be sure we did get it designated. And my notes and staff notes here are not really clear on that. Did you mark that exhibit?
Yes, it was marked and admitted during her direct examination as Bednarsik Direct AGO Cross-Exam Exhibit number 28.
Number 28, and that's why we didn't pick it up here. It's already in the record.
Yes.
Correct. Okay, thank you for that clarity.
Absolutely.
And with that, we will take our lunch break and come back at 1:30. Please mute your mic and stop your video.
John, are you there?
Commissioner? Commissioner Duffley?
Yes, I came home for lunch, like to just do this last hour and a half at the house. So I just wanted to make sure you could hear and see me okay.
Yep, everything audio, video sound good. You're good to go.
Okay, thank you.
Sure.
wait just another minute to see if we can get Commissioner Hughes and Commissioner McKissick. There he is. Okay. Joanne, you ready to go? Okay, Ms. Crawley-Jones.
All right. Okay, thank you. Ms. Podarsek, before the break, I had directed you to the potential cross exhibit 22 that is in 4 parts. Were you able to locate that?
Yes, I have all 4 parts up on my computer.
Perfect. And I'm going to direct you to part 3, which is 162 pages, and I think it begins with section 5, and ask you to go to the PDF, page 96.
So Ms. Crawley-Jones, my part 3 has 32 pages.
Uh-oh.
4 has 170 pages.
Uh-oh.
200 pages.
Oh no, we're working with 2 different documents. All right. Let me see. Can you go to the one that has 170 pages and open that up and tell me how that starts?
This one starts with a letter dated October 30th, 1978.
Okay. Can you go to about 93 of that document? I think we're looking at 2 different configurations, and I hope we can get us together.
So 93 of that document, the number down at the bottom is 2-7.
No, that's not where I'm going either. Now, the way the documents were filed, there was a bit of a misnomer there. Is there any way that you can access the way that they were provided to the commission? And
so I have it. I have someone in the room said to look at part 4. If you give me, it looks like they are searchable, text searchable. So if you give me a word or a phrase, I may be able to find it by doing the text search.
Okay. If you will look for, June 26, 1978, I'm not sure it's going to pull that up.
Is that the exact phrase that I would be searching for?
Well, it's the date on the first page of the letter. If you look at, maybe you could look for his name, Colonel Height, H-I-G-H-T.
I see on one document is a page that says that Colonel Height was the person who signed it. And it has the on of it of October 30th, 1978.
I'm looking for a document, type this in, region Roman numeral 4 of the U.S. environmental protection. We'll see if we can get it that way.
Let me try each one of the documents if you give me one moment.
Ms. Crawley-Jones, this is Commissioner Brown-Bland. What was that number you gave early on that should be at the bottom of the page?
Actually, the one that I'm looking at, there is not a number at the bottom of the page. This is actually, it begins with section 5 of the EIS, and it is a letter with a stamped date of June 26, 1978, written to Colonel Adolph A. Height.
So I was able to find it, Ms. Crawley Jones, in case others are looking for it. At least on mine, it was part 1, page 96 of 162 of the PDF.
Okay. We're the PDF page 96 that we're on the same page. That's exciting. Thank you for your diligence in getting there. Have you seen this document before?
I have seen the document. It says it is 500 or some pages all together, but it has been some time since I've looked at it, but I have seen it one time.
Okay. And just to orient everyone, I believe this was this portion of the document is EPA's review of the draft EIS for the Mayo Electric Generating Plant. And again, just for orientation, make sure we're all on the same page. This PDF page 96 is the first page of the letter. Page 97 is the second page of the letter and shows that it was signed by John White with an enclosure. Are we on the same page? Okay. And then starting at page 90, PDF 98, it says comments on draft EIS Mayo Electric Generating Plant. Is that correct?
Yes, I am on that page.
Okay, perfect. You testified before the break that the company has to make decisions based upon what is known at the time. This document would indicate what was known by the company at that time, wouldn't it?
Yes, it would have. But I also know that specifically for the Mayo EIS, there was a subsequent study that was done that is referenced as the Floyd study. And that was produced in 1979. That, again, you have to look at it in sequence and to look at the entire picture. And I do know that at the conclusion of the environmental impact statement and the evaluation for the Mayo Pond, we did receive a approval from the state agency to move forward with the construction of the Mayo Pond, and we received a NPDES for that. So we got all the approvals we needed from the state regulatory agencies and the federal regulatory agencies in order to move forward with the construction of the pond.
Okay. Now on PDF page 96, which is the first page of the letter, there's 3 points there. I would turn your attention to the third point regarding fly ash and bottom ash transport system. Would you please read that section beginning with water carriage?
It states for number 3, fly ash and bottom ash transport system. Water carriage of fly ash and once through bottom ash sluicing systems are inconsistent with existing and expected, open parentheses, to be proposed in the September 1978 with re-promulgated schedule in March 1979, close parentheses, standards of performance for new sources. It is anticipated that re-promulgated regulations will require dry fly ash handling systems and recirculating bottom ash handling systems. However, even in the absence of such requirements, such systems appear necessary to assure that chronic and acute toxicity conditions do not occur in Mayo Creek, Crutchfield Branch, and the Makeup Water Reservoir. In the absence of a commitment to the use of such systems by CP&L, the project appears environmentally unacceptable. But again, I would like to state that there's a lot of proposed new promulgations, new type of things that are going on with EPA. Great questions for Ms. Williams, who was part of EPA during this time period. And again, we received, after all the studies that we did, we received approval from all the agencies to move forward with the permitted Mayo Basin.
Okay, but looking at this language where it says inconsistent with existing standards, that's pretty clear, isn't it?
So it does state that, but it also says that there are proposals to be re-promulgated. So it is one line in one document. You have to look at the history of all that went on. So There are subsequent things that happened to this information that came out. So again, that would be, especially since this came from US EPA, great thing to follow up with Ms. Williams about.
Okay, but in 1978, Ms. Williams wasn't employed by EPA Region 4, who's commenting on this, was she?
I cannot remember exactly what years Ms. Williams was with EPA, but I will say that this is one document, one time. There's a lot of changes that were going on with EPA related to fly ash, understanding of what was going on, and she would be able to talk about that.
Okay, but in terms, you've been offered as the company's witness for historical management of coal ash, so I'm just trying to get a sense of what you think about the conclusions that were made in this document and how that might align with other historical documents that you were looking at. But thank you.
Well, and I would say, Ms. Crawley-Jones, again, this is a 500-page document, talks about the history of everything. This is one line in that document. I do know that there was additional studies. 1979 Floyd report talked about groundwater, talked about Crutchfield Branch. The NPDES permit we received, we were required to sample out of Crutchfield Branch. So it's you have to put the whole story together.
Now, if you would go to PDF page 101, which is part of the comments that are more details about ash handling. And you see section C that says ash handling?
I do.
Okay. And the last full sentence near the bottom begins, although this requirement, referring to dry ash handling, was remanded, and then this is a quote, further evaluation by EPA has indicated that the technology of dry fly ash handling is feasible, is not excessively costly, and is being instituted by many power companies now. Did I read that correctly?
Yes, that is what the document states.
So in 1978, EPA Region 4 was recommending dry ash handling, wasn't it?
Looking at the words on the page, again, it has been 500-page document. I have not read through all of this in a very long time. It does say that further evaluation by ETA that the technology is feasible, is not excessively costly, is being instituted. It doesn't, just by that one section, it doesn't say absolutely you have to do it. It made those 3 points. Again, go back to what we ended up doing at the site was approved and permitted. So one document, one item, lots of different ideas that were coming through. It says what it says, fly ash was feasible. It did not say it was required to be done at this site.
Correct. But we have been talking about, and you've been testifying as to what was prudent and reasonable, and that what the company's actions were whether they were prudent and reasonable at the time they were taken. And these are factors that were highlighted at that point. Correct.
Factors that were highlighted in one document.
Okay. All right, I'll move on. Okay, on page 61 of your testimony, you talk about the construction of ash basins. So page 61, line 22, you testify that DEP last constructed a new ash basin in 1985. Is that correct?
Yes.
And which one was that?
Give me one moment. It's been a very long week.
Let me do this, and it may help you. I'm going to refer you to Sierra Club Potential Cross Exhibit 17, which was the DEP Kieran Exhibit 5 exhibit with basic ash basin information and history.
So I actually found that the other document that I was looking for. So at Cape Fear, we had the 1985 basin, and then of course at Sutton we also had the basin that was the 1984 basin.
Okay. Do you know how many basins were constructed after 1978? And maybe this is the time to refer you to that Sierra Club Potential Cross Exhibit 17.
So I do have that one in front of me now.
Okay.
What was the year that you mentioned?
If you hold on just a second, Commissioner Clodfelter, we'd ask that Sierra Club Potential Cross Exhibit 17 be marked for the record as Benarsic Rebuttal Sierra Club DEP Cross Exhibit 3.
It will be so marked.
Okay. So my question was, how many ash basins were constructed after 1978?
So it'll probably be easier to go down.
Okay.
The Asheville, the 1982 basin at Asheville.
Mm-hmm.
There was the Cape Fear, the 1985, the one that we mentioned.
Mm-hmm.
And then there was the 1983 at Mayo.
Mm-hmm.
The Mayo, that's a wrong number on there. On there, that was I will say that the Mayo Basin, that is not correct. That one was constructed in around 1981 to the 1983 is when it started operation. Sorry, I wanted to make sure I got that right. And then there is also the 1984 Sutton.
Okay. Did we mention, I think, H.F. Lee Polishing Pond in 1982? Is that correct?
Yes, but that's not a basin. That's not an ash basin. That's a polishing pond.
Okay. But we did mention the Asheville 1982 basin, correct?
Yes, ma'am.
Okay. So we have 4 new ash basins that were constructed after EPA clearly said to DEP in 1978 that wet handling was, quote, inconsistent with existing and expected regulation, correct?
Again, Ms. Crawley-Jones, after 1978, the one document you put together that you showed me had that in there. But again, all of these basins were approved for construction. I would note that the 1985 basin was approved without a liner by DEQ to move forward. So that we did get permits and approvals from our regulators to move forward.
And based on that document, the Kieran Exhibit 5, it also has the tonnage there. So looking at those, we could figure out how many tons of coal ash were placed in those basins after 78. Is that fair from that document?
Yes, it does show ash in tons as of 1/17.
Okay. And
Give me a moment. Ms. Bednarzik, what was that date you said?
1/17/2017.
The total tonnage showed on the Kieran chart, and that was for tons of fly ash placed in those basins after 78. Is that correct?
Tons of ash.
Tons of ash. Okay.
Not necessarily fly ash. It may have been also bottom ash.
Okay. All righty. Do you have a breakdown anywhere of fly ash versus bottom ash for those basins?
Not readily available. I'm trying to think even if I have one, but not that I can, as I sit here today, I can't think of one.
Okay. All right. Okay, let's move to a different topic. On page 53 of your testimony, you talk about, you address the cost recovery for land purchases at Mayo, correct?
Yes.
And on line 16, you describe the land purchase, quote, to mitigate groundwater risk at Mayo, correct?
That is what this states.
Okay. Earlier, I think Ms. Luer asked you about the risks that the company was hoping to mitigate. by purchasing property near the Mayo Basin. Do you recall that?
I do.
And I believe you mentioned that part of the reason was to have, and I think the words you used were more of a buffer. A buffer from what?
So a buffer so we have a compliance boundary at all of our ash basins, and the compliance boundary, and Mr. Wells can go into in more detail and can also make sure I'm getting the distances right, but there's a compliance boundary. It's X number of feet away from the edge of the basin. And that is the where we have to make sure that we have groundwater inside that compliance boundary. Of course, the compliance boundary is a state item, is under CAMA. Under the federal CCR rule, groundwater has to be managed back to the waste boundary. So it's a different level there. So, and I think I mentioned in earlier testimony that we do not have 2L impacts beyond the compliance boundary at Mayo. So when you look at the why we purchased this property, there was neighbor concerns about groundwater in the area. We didn't have any impacts in that area, but when I mentioned earlier, making sure we had more distance, a little bit more of a buffer, so it helps us push out that compliance boundary, because we were able to move the property boundary out a little bit, and we can continue. We had that buffer area to make sure, as we're continuing to monitor, that we had enough distance that if something were to show up in the future or anything different happen, we have that full compliance boundary. And again, Mr. Wells can talk about also that purchase in more detail related to anything with groundwater.
Okay, but in general, can you describe where the property was located that was purchased at Mayo? Was it along the Crutchfield Branch?
I do know, Ms. Crawley-Jones, that it is on the northern side of the site closest to the Virginia border. As I sit here today, I can't picture exactly where it is in relationship to Crutchfield Branch, but I do know it's on that northern side closer to the Virginia border.
Okay. I want to refer you to Hart Exhibit 54, which was entered as AGO Benarsic Direct Cross Exhibit 10. And this is the CAM report from Mayo. And it's got some sources in there that I think can help us a little bit on this piece.
I do have that in front of me now.
Okay. And if you could go to page 51. And I believe you'll see
Ms. Crawley-Jones, mine doesn't have, since I'm looking off of the hard copy, if there's a number at the bottom. That
okay.
There's also a number of attachments, so that may also help to the attachment.
Right. I'm getting to the PDF itself, and then let me see how I can find. It's the map. It's the first site map, and I believe it follows after attachment B, if that helps. Maybe figure 1-2.
I have that in front of me now.
Great. So just to orient everyone, we've been talking about the compliance boundary. Would that be the purple dashed line on that map?
Yes.
And then does this help? Is that northern property outside the compliance boundary towards the Virginia border? Is that your understanding of the property that was purchased?
Yes.
Okay. And then just to get a little bit of orientation. Monitoring well 16 is the set of monitoring wells that's in that located adjacent to Crutchfield Branch and in that purchased property. Is that correct?
I do see monitoring well 16S, the pair. So there's a SD and 16BR. What I don't have on here is the property borders, and I'm sorry, I do not, based upon this, can tell you if that's inside or outside without seeing a map with the property borders. I'm sorry, okay. I can't remember. But
Subject to check, that's a well outside of the compliance boundary on the Crutchfield Branch. Can we agree on that piece?
It is a well outside the compliance boundary as shown on this drawing. And then also it appears to be on a stream, and that would be Crutchfield Branch. Okay. And in that 1978 document, EPA stated in that same EIS that they did not believe that the use of the proposed pond for ash disposal was an acceptable use of Crutchfield Branch. And that would be what was dammed here for the creation of the ash basin. Is that correct? Yes, but I would also state that and I'm trying to pull up the 1979 Floyd report, it actually references the Crutchfield Branch and what came out of that 1979 evaluation. Mr. Wells may be able to pull it up better than I can because he has information on this. But I also do know that the NPDES permit included sampling within Crutchfield Branch. And that was how the department looked at it and said, this is a sampling point, an important sampling point. And Mr. Wells has more information about that NPDES permit and those samples.
Okay. And I believe you've testified a couple of times now that there were no exceedances beyond the compliance boundary at Mayo. Is that correct?
At Mayo, we are not having to do a extraction system or extraction treatment at Mayo because there are none. We've had 4 quarters, and that is what we provided to the agency that shows we do not have impacts beyond the compliance boundary. What I don't know, as I sit here today, again, better question for Mr. Wells, if at any time there was any type of hit in one of those wells, but I do know we do not have to do any type of groundwater correction action to pull a plume back into the compliance boundary.
Okay. So based upon those 4 quarters, but you're not testifying that there's never been an impact to the Crutchfield Branch or groundwater related thereto.
I think if I haven't made myself clear, it's related to what is required under CAMA and looking at background information. Mr. Wells has more detail on that, but I do know that we do not have to do a groundwater corrective action to pull a plume back inside the compliance boundary because we do not have a plume that's outside that compliance boundary.
Okay. Just again for orientation.
Excuse me, Mr. Marzo, we've lost your video.
I keep having the wrong finger slide over with this new setup. Sorry about that.
I've been having the same problem. I just want to make sure you were still with us.
Yep.
Go ahead. I'm sorry for the interruption.
No worries. Looking back at the map, we've identified MW16, the set, and then MW3, that's a monitoring well that is inside of the compliance boundaries, correct?
Based upon this drawing, which is really small, I don't know if it's right at the compliance boundary or inside or right outside. Mr. Wells may know specifically where that is, but I would have to have a much bigger picture to be able to see where that is. It appears to be placed either right on top of the compliance boundary, so I don't know if it's inside or out.
Okay. And I'm not sure you've got a hard copy, but on the digital copy, the next page begins reporting out various data from the groundwater monitoring. Would you agree with me that on these sheets, yellow indicates exceedances?
Yellow is an exceedance of the 2L standard.
Okay. And go one more page in, because I believe the next, it's PDF page 53, but it's the next page of data is where you find the results for MW3 for those 4 quarters.
I do see MW3.
Okay. And when you look there, there are exceedances for boron. Generally, boron is not a naturally occurring substance, correct?
So it is not, but again, I would also say that although this says location with respect to groundwater flow direction, down gradient, and saprolite, you need to look and see where it is. And we already talked about, I don't know if that's one's inside or outside. And it also does not take into account any type of background. So I would say that I would go back to, I know in working with the agency, looking at background, looking at what we have provided to them, we do not have to pull any type of plume back inside of a compliance boundary at Mayo. Looking at these, again, Mr. Wells may have more detail, but that is a fact that I know with the agency today.
Okay. And I'm just trying to get a high level understanding of some of this, and I'm not trying to get into the weeds, but my understanding, and just trying to make sure that boron is one of those indicators of a plume, of a coal ash related plume. Is that correct?
Yes, and actually we used boron when we did our modeling that we submitted to the state with our groundwater corrective action plans. We used boron, I believe, and again, Mr. Wells will know for sure whether or not, I believe we used boron as kind of our key of what we would look at when we did our modeling. Okay,
and it's subject to check. I know you had a small map, but I'll represent the monitoring well 3 is inside the compliance boundary. So I'm not suggesting that this is an indication outside there, but inside the compliance boundary, right on Crutchfield Branch, this page 53 does show exceedances of 2L for boron. Is that correct?
So based upon the document, the document shows what the document shows. But again, I would go back to discussions with the agencies where we are today. We do not have to do groundwater corrective action plan to bring anything back inside of a compliance boundary.
And I get that. I understand that. You've been very clear on that. But that also, monitoring well 3 also shows exceedances inside the compliance boundary for manganese and vanadium, correct?
Of the 2L standard, what I don't know is what the background standard is for those constituents.
Okay. And then if you go to the next page, which is 54, you have to go, it's kind of the bottom of the middle third of the data sheet. I believe that's where you start seeing the results for monitoring well 16, which we agreed was outside the compliance boundary. Do you see those?
Yes, and actually in here it says off Duke property, but again, that's based upon this time frame, and I'm not sure if that was inside the property we purchased or not. So, but it does say off Duke property, and so that goes off Duke property. It's outside the compliance.
And the sampling dates there are what you suggested, the 4 quarters from July of 2018 to April of 2019. And you see those?
I do.
And granted, it is not an exceedance, but do you see for MW16S, the saprolite shallow wells, that boron is showing up in that well?
I do see that, and that's actually why we will continue to monitor. And it is something that, of course, we will do. It's not like we will stop. We will continue to monitor and work with the agency if anything were to change in the groundwater.
Okay. And then do you also see that there is a 2L exceedance for iron in 16S?
Yes, but I would go back to, this is just showing 2L exceedances. It does not do any indication of background. And when you look at, with 2L, you also have to look at background at the end of the day. So this is a straight comparison with 2L from what I can tell. Again, Mr. Wells may be able to provide more clarity, but you also, of course, have to take into account background levels.
Okay. And there was additional groundwater monitoring data that was presented as part of the comprehensive site assessments for these sites, including Mayo, wasn't there?
Yes, there was a lot of groundwater data that was provided.
Some of that beginning as early as 2015 from Mayo. Would you be surprised? Subject to check. Sampling data from 2015 through 2017 is available in addition to the 4 quarters that are shown on this particular exhibit.
Mr. Wells will be able to tell you the years for groundwater data, but all the data that we have, all the groundwater data has been provided to the agency. It was also, of course, provided to all the interveners.
Okay. And so the documents will show what the documents will show relative to exceedances for pH, cobalt, manganese, and boron, or there's not a 2L exceedance for boron, but for pH, cobalt, and manganese in these well 16. So if that's there, and you said you didn't have knowledge of those particulars, and that would be something for Mr. Wells, correct?
Yes, that is a good question for Mr. Wells.
Okay. Now, are you aware that DEQ concluded that the groundwater plume of boron at concentrations above 2L standards had migrated beyond the compliance boundary and had reached Crutchfield Branch?
I do know, and I testified this the other day. I can't remember which of the interveners asked me this question about the April 1st, 2019 order from DEQ for excavating, and the fact that it did have in there an indication that there was a plume outside the compliance boundary. And I believe I also discussed that was part of our filing with the Office of Administrative Hearing, and specifically we called out that we do not have impacts beyond the compliance boundary. So anything beyond that related to groundwater, again, Mr. Wells is to talk to with groundwater.
Okay. And that same document that I think you referenced that's been, it's now marked as Benarsic Rebuttal AGO DEP Cross-Examine 2, number 2, but that is that April 1st order. Were you aware that DEQ also concluded in there that manganese and strontium were detected more than 500 feet beyond the compliance boundary?
Again, Ms. Crawley-Jones, that was all part of one of the reasons, one of the multiple reasons, all laid out in our filing against the administrative, to the Office of Administrative Hearing in our response to those orders. And there was information related to groundwater, no matter what the constituent is, related to the compliance boundary, specifically at Mayo.
And so the company just disagreed with DEQ's conclusion about the groundwater data submitted. Is that correct?
I would point to the Office of Administrative Hearing, what our filing was. We have had, I did talk to our groundwater experts in that area and asked them, this is what the April 1st order said. What did the conversations with the agency, did they know? And based upon the conversations I have had with Duke Energy, subject matter experts who had discussions with DEQ at that time, is that it was clear the information was that we did not have exceedances beyond background, beyond 2L, beyond the compliance boundary. Now, of course, DEQ had what DEQ had in their document. And we, of course, disagreed with that. And that is why we ended up having the order, or why we went back and went to the Office of Administrative Hearing. But again, I would go back to today, working with the agency, we do not have to bring any type of contaminant plume back inside of a compliance boundary at Mayo.
The conclusion that DEQ reached about there having been impacts past the compliance boundary was based upon the data that the company reported to DEQ in its comprehensive site assessments, wasn't it?
And the reason we ended up contesting that is because what came out in that order, we looked at it and said that is not correct. And subsequently, where we are today is we do not have to bring anything. There is nothing outside that compliance boundary we have to bring back. I think all those documents speak for themselves. I don't know what DEQ was thinking when they were putting that together, but I do know where we are today related to groundwater at Mayo, related to the compliance boundary. And anything on groundwater, again, I think I said it a couple times, Mr. Wells is a good person to also talk about this.
In 1978, the environmental impact statement warned against using Crutchfield Branch to construct an ash basin. And it turned out, based upon DEQ's conclusions, that warning was correct because there ultimately ended up being impacts to Crutchfield Branch. Wasn't that information known to the company at the time? And you've mentioned the Floyd report a number of times. And doesn't it appear now looking back that Floyd was wrong?
I would say, no, I don't agree with you. I found the Floyd report. I have it in front of me. The very last page in the Floyd report says it is difficult to imagine that any significant adverse impacts on the groundwater aquifer could be caused by ponding of the ash waters at the proposed site. That was one I was able to pull up quickly. I would say our groundwater data today and what we have to do related to our compliance boundary aligns with what this is. And then any other questions you have on groundwater, please refer to Mr. Wells.
All right. I have no further questions.
All right. Thank you, Ms. Crawley-Jones. These are the only parties that I have any reservation of cross-examination. So let me ask for the record, are there any other interveners or parties who have questions for Ms. Bednarsik at this time? If not, Mr. Marzo, we'll come back to you for a redirect.
Thank you, Commissioner Clodfelter. Just a few questions. I'll start probably from the back and move forward. Ms. Bednarsik, you were just asked several questions by Ms. Crawley-Jones regarding Mayo and the EIS in particular. And I think you said you had the Corals report in front of you now. Not the Corals report, I'm sorry, the 1979 report in front of you now. Mayo and the Edwin Floyd report.
I have that in front of me. At least the main document. I don't know if there was attachments, but the main document I have in front of me.
And I heard you read a portion of that, and I want to make sure that we understand, for clarity's purposes, that we're talking about the same portion of that report. Can you reference page 14 of that report? Is that?
So I was actually talking about the next page. I'm on page 14 now.
Okay, if you see the first full paragraph on that page.
Yes, I do.
Would you mind reading the first full sentence, which goes a few lines down?
Soil conditions at the proposed ash pond site at the Mayo Electric Generating Plant are adequate to provide excellent protection to the groundwater aquifer, both in preventing significant leakage from the pond and in reducing the concentrations of the heavy minerals by filtration before the leachate reaches the aquifer.
Okay, thank you. So a very different opinion than what Ms. Crawley-Jones was talking about in the 1978 report. Is that correct?
Yes.
Okay, and I think you mentioned subsequent to that EIS draft that the ultimately received permits for a ash basin at Mayo. Is that correct?
Yes.
Okay, and I think Ms. Crawley-Jones asked you a number of questions around industry standard and your understanding of industry standard. Let me ask you, is one way of understanding industry standard understanding the common practices that are occurring across the industry with your peers?
Yes, it is.
Okay. And you're familiar with the Bonaparte report, correct?
Yes, I am.
Okay, and the Bonaparte report identifies at least 4 states within Region 4 of EPA, correct?
Correct.
Okay, and are there a number of unlined basins that were in existence even up to the point in time the CCR rule was put in effect?
Yes, there were.
Okay, so following the EIS report that Ms. Crawley-Jones showed you, there was still a common practice across the industry to use unlined basins for sluicing ash. Is that correct?
Yes.
Okay. And for the record, Commissioner Clodfelter, just to make sure the record's clear, the report that I identified, I'd like to have it marked, which is the 1979 Edwin Floyd report for the evaluation of the potential for contamination of the groundwater aquifer by leachate from the coal ash storage pond at the Mayo Electric Generation Plant site. I'd like to have that marked as Bendarsic Rebuttal DEP Redirect 1.
It will be so marked.
Okay. Thank you, sir. Just a few more questions. Ms. Bendarsic, now you were asked several questions by Ms. Jose regarding the Asheville plan, and I think she asked you a number of questions about the potential to build a landfill at that facility in the prior period of time, back in that 2015 or so time frame. You call those?
Yes.
And did the commission already opine on whether it was feasible to develop a landfill at Asheville in that time period?
Yes, in the time period that Mr. Karen talked about. Yes.
Okay. Did the commission find in Duke Energy Progress's last rate case order that the Mountain Energy Act effectively made construction of a new on-site CCR landfill technically infeasible during the development of the combined cycle?
Yes, that is my recollection.
Now, you're proposing to build a landfill today that won't be completed until 2021. Is that right?
The current schedule is that we will be submitting and hopefully starting to be able to put ash in that landfill at the end of January, beginning of February of 2021.
Okay, and does that change the fact that no on-site landfill at Asheville could have been reasonably developed from September 1st, 2017 to December 31st, 2019?
It does not change the fact it takes a number of years to put together packages, get permits, build all of that together. We are doing it, of course, for the 1.3 million ton landfill. We started construction right after the combined cycle was done and cleared the area so we could have it. And we're moving really quick for a small landfill.
And that was my next question, which was the combined cycle was complete and the coal plant was shut down at that point. Is that right?
Yes, and actually, it's actually very interesting to note because I'm also over our demolition group. In order to build that new landfill, we had to quickly move the coal yard and get that clean so that they could utilize the coal yard, which was, of course, in operation when the coal plant was operating. Had to have that nice and clean so that they could use some of the fill dirt as they were building the landfill, putting it inside of the coal yard area. So it really has been like a domino effect to make sure we utilize the area appropriately.
And by phasing that work, have you created an opportunity to save customers by being able to pursue an on-site landfill at this point?
Yeah, so by doing the 1.3 million ton landfill on site, in our evaluation, we are looking at a $20 to $30 million savings for our customers and for the company.
Now, Ms. Jost also asked you some questions about char, and I think I can ask these without eliciting any confidential information, because she asked you primarily about the Sanford Cullen mine. And I just want to ask you, did char purchase that mine to undertake the contract?
Yes.
Okay, and are there obligations that char has now that it's assumed by virtue of purchasing a mine that it has ongoing obligations related to that?
Yes.
Okay. And is the fulfillment fee in part intended to address what are ongoing obligations for essentially buying a mine and that mine not being used, but still having the obligations to address that mine environmentally and otherwise?
Yes.
Okay. Commissioner Claufelter had indicated earlier today that he had punted a question to you, and I was just going to ask you regarding the cost breakout for Sudden Roxborough for the corrective action necessitated by exceedances of the 2L standards beyond the compliance boundary. He asked you to try to figure out if you could break out cost data, and that was sort of termed a homework assignment. And I'm going to ask you, did you do your homework?
Yes, I did. I reached out to the accounting group, the person actually Mr. Doss referenced this morning, because I took that down as a homework assignment, not as something for Mr. Doss. So we did reach out and ask, and really, when we talk about groundwater and what may have had happen, what we may have had to do under the 2L standards related to groundwater around the basins, we don't know where we sit today, what we would have had to do. The corrective actions or what would have happened under the groundwater, under 2L by itself, there's a lot of different ways we could have worked with the agencies to move forward. We don't know what we would have had to do, if we would have had to put in the wells that we had to under CAMA and CCR or not. The number of wells, what would have happened. So once CAMA and CCR came along, it really, the door was closed on just under 2L, and the prescriptive, the requirements, the groundwater requirements, the sampling, the assessment under CAMA and CCR are very prescriptive. And Mr. Wells can talk about that in more detail. But when I discussed it with our accounting people, as soon as CAMA and CCR came around, their asset retirement obligations, in those, it's all tied together. And because of the requirements under CAMA and CCR related to groundwater, which is tied all with the asset and the retirement of the basins, are all tied together. So you really can't look at it and say, well, what would have only been under 2L versus CAMA and CCR? As soon as that happened, the accounting people said 2L is kind of is gone. It's not gone. We still have to, of course, comply with 2L. But the actions that we have to take are CAMA and CCR.
And I think you said that's because CAMA and CCR are prescriptive. Is that what you termed it as?
Yes, they're more prescriptive. Of course, CAMA has the compliance boundary requirements related to groundwater. CCR has a different compliance boundary. You have it's at the waste boundary, which is a lot closer than the compliance boundary. So you have to put all of that together, different requirements required underneath those new obligations.
Okay, so trying to compare what you had done for 2L rules and CCR is very different because you got a prescriptive requirement on one hand, you don't on the other hand with the 2L rules. Is that generally correct?
With 2L, we don't know what would have happened with underneath 2L by itself. Where we sit today is we have to comply with CAMA and CCR.
Okay. Thank you, Ms. Bedarczyk. Commissioner Claufelter, that's all the redirect I have.
Great. Thank you, Mr. Marzo. Let me tell you what I'm going to propose to do. We are right about at 2:30. I'm going to vary a little bit our adjournment time for this reason. I'm going to give my colleagues a chance over the weekend to collect their thoughts. This is the last time we'll get to talk to Ms. Bedarczyk, at least in this series of rate cases. And it might be useful for the commissioners just to have a little bit of time to reflect and be sure we get everything in the last minute. So I'm going to hold commissioners' questions over. Ms. Bednarsik, unless you were planning on taking a long vacation starting on Monday, I hope that won't disrupt you too much. But I don't think we'd finish with you anyway. I think you're likely to have enough commissioner questions and then people wanting to ask you about it where we probably wouldn't finish anyway. So with that said, I'm going to hold commissioners' questions and we'll pick up with those on Monday. And perhaps that might even enable us to focus them a little more tightly and get you through quicker. Mr. Marzo, if that's okay. Let me then address one other issue. Ms. Crawley-Jones, can you come back? Are you around?
I am.
All right, let me just have you think about this also over the weekend. I'm going to make a suggestion, and I've asked the court reporter to consider this as well, but I want to ask it of you. With respect to your rebuttal cross-examination exhibit number 2, that's the EIS that was served in electronic form, I'm going to suggest that the way we bring that into the record when you are ready to move it is that in the record, in the actual transcript, we simply have a reference to the hyperlink to the website, but that we also then ask you if you would provide the court reporter copies of the pages, the hard copy pages that you and Ms. Bednarsik specifically called out of that larger document discussed. And if the court reporter tells me I'm not crazy in doing that, I'm going to suggest that might be the most efficient way to handle that exhibit when it's ready to come into the record. So if you'll think about that, and Mr. Marzo too, if you'll think about that also, I think that may be the best way to get that document wrangled into the record, as it were, since it's so massive.
I appreciate that. I had a note that we needed to address that issue, so you were reading my mind. Thank you so much.
I'm trying to keep up with you, and as I say, that'll give you something to think about over the weekend. So let me ask the parties, is there any other administrative or procedural matter that we might usefully take up here in a few remaining minutes?
Commissioner Clodfelter?
The exhibit policeman has returned. Mr. Mehta.
This is not a police matter. At least I don't think so. With respect to the EIS document.
Yes.
Would it, assuming the document is moved into evidence, the entire document will be in evidence? Is that correct?
Well, it would be, yes.
Okay. I think that was my confusion as to as the entire document as opposed to the handful of pages that were actually discussed.
I think that's correct. And what I'm suggesting really is that how the transcript reflects that fact is to have the hyperlink in the transcript and then the hard copy pages, but that the entire document is actually in the record of the case. I'm trying to avoid having to have our court reporter have to copy a 500+ page document and then have to manage that. So that also reduces rate case expense, Mr. Mehta.
A very good outcome there, Commissioner Clodfelter. And we have managed to kill probably a small forest at this point. Paper copies of everything, so I am all in favor of that. I just wanted to be sure that the entire document was in evidence.
The entire document will, and the record will so reflect, so that for purposes, should there be subsequent proceedings in the case and there's a need to refer to other portions of the document, for example, the entire document will be considered part of the record. Okay.
Thank you, Commissioner Clodfelter. I appreciate it.
Mr. Robinson, I see you reappear. Is there something you want to take up?
No, Commissioner Clodfelter, just wanted to confirm there was nothing. However, the company will provide an update on late filed exhibits on Monday. So we'll be able to give the commissioner a roadmap as to what's still outstanding and when it will be.
That's great. As we've been proceeding through the afternoon, Mr. Robinson, I've also been having some exchanges with commission staff. And I think you should anticipate, if you haven't already done so, that whenever we'll make the following request if we haven't done so. Whenever in the Duke Carolinas case, there was a request for a late filed exhibit that would contain data or compilations pertinent to Duke Carolinas, you will very likely get a parallel request so that the information is pertinent and compiled as to Duke progress. So we'll be tracking parallel on those late filed exhibit requests. If we haven't officially done that, we'll probably do that at the end of the close of all the evidence, but you might go ahead and anticipate it if you want to do so. And that'll just move us that much further down the road.
Will do. Thank you, sir.
Okay. All right. If that's good for the day, then we will recess for the weekend. And remember, again, we're reconvening on Monday at 1:30 p.m. All right. Thank you. Everyone have a good weekend. Please turn off your mics and stop your video.